welcome to Crime and Court. My name is Heather, and this is going to be voiceover only, and you'll know why in a bit. We're going to be watching video for most of it. At the very end of the video, stay tuned though, because we're going to go over Sgt Lank's complaint. It's actually the complaint from the Lopilato brothers, who were illegally arrested by one of the officers that was investigating in the Canton Cover-Up. He was Sgt Michael Lank, who is also a good friend of the Alberts and wasn't supposed to be working that night, but got called in specifically to go and question his buddies about a crime that occurred, so as to make sure that they didn't get any, so as to make sure that they weren't suspects, I guess, and help frame an innocent woman and cover up the unaliving of a Boston police officer. So that's what this case is about. And Karen Reed, the woman you see up in the center with her, she's kind of got a side eye going. She is going to be going to trial starting April 16th. So that is this Tuesday. They are selecting a jury for her trial, and once a jury is selected, I assume they'll begin. So that's kind of where we're at that, even though there's so much evidence that goes to inculpate others and exculpate Karen Reed. We're still going to trial for some reason. I don't know why, but this episode, which is my 24th episode within my series, episode 24, Bombshells, dropped at the pre-trial hearing for Karen Reed. So we are going to go through the key moments from the pre-trial hearing. We're going to go through the bombshells, all the good stuff. So right now, we are going to hear Judge Cannone. This is one of the things that came out during this hearing. There will be a juror view of the crime scene at 34 Fairview Road. So let's take a listen here. Oh, let me unmute you guys. There we go.
Well, I'm probably starting with one. You could have saved yourselves time in writing the motion regarding the view, because you both want a view. I will conduct a view. You need to talk because you have different locations.
Yeah, and we've, upon consideration, Your Honor, the Commonwealth has asked for a view of 34 Fairview Road. We would be satisfied with a view of...
So you don't need to go to the waterfall?
I think that we can just agree to go to that one location.
All right, so you all figure out the view. I am going to take under advisement your request of the defendant coming with us. You know that there are all sorts of things I have to consider before deciding that.
Thank you.
So that part is under advisement.
All right, so a view is happening, but they're not sure yet if the defendant will be partaking in the view with the jurors. So the next thing that I find very interesting is Judge Cannone's reaction to a motion that was filed by both sides. So here you go. Oh, there we go. No, sorry. Where am I? Here we go. Okay. My thing wasn't set up right. Sorry. All right. So Judge Cannone wants the talk of Turtleboy allowed for some reason. Her reaction is very strange. So yeah, I think it's strange. Both parties want talk of Turtleboy out. No mention of him throughout the trial. They both stipulated in a motion they don't want to talk about Turtleboy. And obviously Turtleboy is part of the story because he has been reporting on this for well over a year now, and he's been really, he's been opening our eyes to what's really been going on, I'll say, there. So with that, let's listen to what Cannone has to say.
Before the end of today, figure out exactly what you want to do with the view. Mr. Lally, your...
Oh, hold on. I didn't get us there. Let me grab the link. I forgot to do that. There we go.
On what's the defendant's motion to exclude irrelevant and prejudicial evidence regarding alleged harassment and or intimidation of a witness, and the Commonwealth's for different grounds and different scope, actually. Motion to exclude mention of Aiden Kearney, aka Turtleboy, and his pending criminal charges for witness intimidation. So, though you both agree it's out, that doesn't necessarily mean that I agree with you that it should be out. I understand that the nature of the harassment, mindful of the grand jury minutes that I've read, that in response to some of the questions posed by those at the U.S. Attorney's Office, the answers explained away some conduct as a result of the extraordinary harassment witnesses were undergoing. So I'm not sure I agree with you. So go ahead and
Isn't that ridiculous? Both sides want it out, and she's like, I'm not sure I agree with you. She's such a bitch.
try and persuade me, but what I'm
Try and persuade me.
inclined to do is keep it out in the case in chief, but Commonwealth said you told your witnesses not to discuss it. So I'll hear the defendant.
Just a moment.
I guess I would start, Your Honor, by saying that in order for evidence to come in, it has to be elicited by a party. It has to be offered by a party. You're being told that the Commonwealth does not intend to elicit this evidence and that the defense does not intend to elicit this evidence. So I guess the question that I would direct to the court is, do you intend to follow up with questions?
I'm not questioning the jury. It's clear that it may be a response, a natural response by a witness that neither one of you intended to get as a reason for something, right, that I'm not going to sanction the witness because I allowed the Commonwealth's motion.
Sure. So,
Mr. Yannetti,
yes.
So it's clearly you try your case the way you want to try your case, and the Commonwealth decides how they want to do it. But I am not tying the hands of witnesses to natural responses to questions. So I'm taking this under advisement. If you open the door, it comes in.
Oh, I completely understand that, Your Honor. I will say that I think probably, I don't want to speak for Mr. Lally, but I...
So don't speak for Mr. Lally. I'll hear from him in a minute.
I'll speak for myself then, if the court will allow me,
Wow.
which is that if a witness opens the door to, a further explanation of this, that could give rise to both sides
Right.
exploring that, which, I suppose we'll deal with that when it comes
Right.
to it.
The way the motion's written, it would be prohibited, and witnesses, I'm not tying the hands of witnesses to natural answers that are the result of questions asked by counsel.
Right, understood.
Okay?
So basically, Judge Cannone just gave permission to all the Alberts and the McCabe's and all the liars in this case to continue to lie on the stand about how much they've been harassed by Turtleboy and Karen. And how much psychological and emotional damage it's done to them. BS, come on. They have always been the aggressors in these instances. They are constantly bullying and threatening and manipulating the situation in their favor in life in general. Not just the O'Keefe case, but just that's how they are. They are connected people, and they use their names and their power to get away with anything, literally with ending someone's life. So they are using their power and connectedness to get what they want. But let's not. Let's let them talk about how scared they are of Turtleboy on the stand. Come on. Anyways, all right. So that's pretty much where she left that. Let's go on to the next section where I wanted to, or one of the next key points here. So let me get my thing ready and transition. Where are we? Here. All right. So the defense has a motion to exclude DNA of a hair that was found at the on the tail light, near the tail light, on the bumper, wherever, where have you. They found it, somewhere in that vicinity. And it is apparently, they believe, John's hair. And that proves that she hit him or something. I don't know. Even though his hair being on the car okay, so it's a miracle that it stayed on the car for that long because, first of all, it was in a blizzard. Second of all, Karen drove from, not only when she woke up, so if she hit him at midnight-ish, 12:30, and then she drove home from the 34 Fairview Road to John's house. Then at 5 in the morning, she gets up and drives around in a blizzard looking for John all over the neighborhood. And then she meets up with Jen McCabe. Jen McCabe drives it back to John O'Keefe's house. Okay. And then she, they go back out and they look for John in Carrie's car. But then after everything happens, they find John and she is taken to the hospital against her will for a blood alcohol sample. She drives her car to her parents' house. After that, it's picked up and towed. This is all during a blizzard. Picked up and towed from her parents' house with Trooper Proctor and Buchanan towing it away to yet another 45 minutes. So Karen's parents' house was 45 minutes from where she was at John's, and now it's being towed away another 45 minutes on the road, towed away, yet this hair still is stuck on this car somehow through this blizzard and all that movement. And we're supposed to believe that there's a hair that they found, period, but yet that it's John's. And if it's John's, then it proves that she hit him. I don't buy it. But anyways, here is what Adam Lally has to say about the DNA testing, because the defense is trying to exclude it because the DNA testing has not been done in time. The report won't be finished in time. So here we go. Oops, here we go now. So that's what we're about to hear, this motion. And who delayed it? That's the question.
Motion regarding the DNA, regarding excluding the DNA. Mr. Lally, why should I not allow that motion?
For a couple of reasons, Your Honor. Number one, what I can provide to the court by way of update is that most of the testing with regard to that item is complete. So first and foremost, the item is hair. That was confirmed by the Bodie testing prior to them conducting any sort of mitochondrial testing. The mitochondrial profile, the partial profile that was generated in regard to the hair sample is complete. The mitochondrial DNA profile in regard to Mr. O'Keefe's sample is complete. The preliminary analysis that I received by way of email from Bodie yesterday indicated that they were consistent with each other. I asked for some sort of preliminary report or something that I could share with counsel based on their lab's accreditation. That did not permit them.
That, by the way, is Judge Cannone breathing very heavily into the mic. She does it every hearing. She needs to back up a little.
them to release anything by way of a report prior to it going through a full review process. My understanding is that not only that process, but the entire lab file should be produced by Tuesday. On top of that, what I would state as far as any sort of prejudice the defendant appears that they've suffered as a result of that, there is still zero reciprocal discovery that I've received in regard to anything from counsel. And then part of the delay, at least a portion of the delay in this specific testing, as the court is aware, as you've had a chance to review Bodie Technologies' observance policy as far as outside experts, there was a significant delay in hearing from counsel and for the defendant in regard to whether or not they wish to have someone present prior.
How long a delay?
I believe it was at least several weeks, if not a month. I mean, we spoke about it in person in December, and I don't believe that
My order was in November.
Correct. So when we received your order was in November. What took a little time on our part was to get the samples taken from the troopers in regard to the other testing, and in order to get all of those items shipped and transported from the MSPCL to Lorton, Virginia to Bodie.
When was that done?
Late November.
Go ahead.
And then there was a evidence viewing, which both counsel attended. We spoke about it there. I think that was December 1st. And then I waited a few weeks, never heard back, followed up on it, and eventually heard back with regard to them not wishing to have anybody present for that.
When was that?
I don't have a specific date offhand, but
I need you to find it.
I can.
All right, so I didn't know that the defendant decided not to have somebody there.
Right.
And that prolonged it? They weren't able to go forward, right?
Yes.
How long will it take you to find that information?
Shouldn't take too long. I would need to check my email.
All right, I'm going to take a 5-minute recess.
Thank you.
All right, so as you can see, Judge Cannone seems annoyed. Where are we? Okay. So now we're going to go on to, oh no, we're still on this. Sorry. We're not going on to anything. We're still on defense's motion to exclude. The DNA. I gotta find the new link. That's what I'm doing. I have so many things I'm trying to click back and forth on here. And that's a very loud car that just went by. I apologize. Alright, let's get to, so she went to break. She wants proof of how long the defense team delayed things. It doesn't matter if Commonwealth delayed things at all, but just the defense. Whoops.
Confirming that they do not wish to have observation for testing in the hair sample of Bodie.
All right, so that was about a month after my order?
Correct.
All right. And the defendant's asking me to exclude this in part because of the late disclosure of the information.
Yes.
All right, I'll hear from the defense on this, and then I'll give you an opportunity to address it, Mr. Lally.
Judge Cannone literally said in the last hearing that she would accept a motion to exclude the DNA because from this hair sample because it wasn't ready. And now she's changing her tune because that's what she does with when it comes to the defense. She doesn't want to give them anything.
All right.
Gosh darn it, I keep doing that. Sorry.
Thank you, Your Honor. I'd first like to address the timeline that Mr. Lally has just explained to the court. First of all, we were not made aware that we were allowed to test based on Bodie's protocols and procedures until December 1st. We were given a letter saying it would cost $21,000 for our expert to sit in on that testing. We reviewed that letter. We told Lally, Mr. Lally, that it was most likely we were not going to have someone independently watch the testing because of the price.
When was that?
December 1st.
When? December 1st?
On December 1st.
Okay.
We confirmed that in writing when he emailed us again on December 22nd. And I would note for the court that Bodie did not receive the hair from the Commonwealth until January 11th.
Okay.
So there was no delay on our part. As the court knows, to date we have received no reports from the Commonwealth regarding Bodie Technologies' analysis of the DNA. The Commonwealth has engaged in repeated and inexcusable delays regarding the testing of this particular item of evidence, which at this point is sanctionable. The hair has been in law enforcement custody for more than 2 years, Your Honor. On February 1st, 2022, Massachusetts State Police criminalist Maureen Hartnett purportedly recovered a hair from the bumper of Ms. Reed's vehicle. For a full year, the Commonwealth did nothing. Finally, on March 6, 2023, criminalist Maureen Hartnett got around for the first time.
Sorry, criminalist department? Is that what you said?
Criminalist Maureen Hartnett
Okay, yes.
got around to conducting a visual inspection of that hair for the very first time. On March 6, 2023, she opined that it appeared to be human. However, subsequent discovery produced by the Commonwealth revealed that she had failed her proficiency test in that precise subject matter only 1 month prior.
Oh, damn.
Then, on August 25th, 2023, the Commonwealth submitted that hair to the Massachusetts State Police lab for DNA testing, and it was forensically determined that no human DNA was detected. Almost 6 months later, the Commonwealth made their third attempt to find evidence establishing that the hair was somehow probative in this case. It is now 4 days before trial, and we are told that we're going to receive this on the day trial is set to begin. Pursuant to Massachusetts Rule of Criminal Procedure 14C, subdivisions 1 and 2, the court has the discretion to exclude evidence based on the Commonwealth's failure to comply with its discovery obligations. There's no excuse for a 2-year delay. We immediately conferred with counsel when he notified us as to what the requirements were going to be if we decided to have an expert present for testing. We got back to him the day that he emailed us following up about that, and they didn't even bother sending the hair to the lab until weeks later. So I don't think it's fair to blame the defense for a 2-year delay in this regard. As the court may know from the notices of discovery, we've received an overwhelming amount of evidence. This week, last week, the week before that, we're on the eve of trial. It is not fair to throw at us yet another item of evidence that we have to retain an expert to assess. We have to review, we have to make tactical decisions. That's not a fair position to put the defense in. We've been asking for a continuance. I think the only fair thing if the court is going to force us to go to trial is to exclude this evidence.
Okay, thank you very much.
Thank you, Your Honor.
Mr. Lally?
Yes, Your Honor. Again, not faulting counsel.
I don't understand why he gets to talk twice about it when it's actually the defense's motion to exclude it, and now they have to like defend themselves for some reason because, of course, the Commonwealth does what it does and it blames the defense for everything. But anyways.
Counsel for any sort of 2-year delay period, but there was a period of time, given sort of the close nature of when the Commonwealth is receiving this information, that a couple weeks or a few weeks in this case do matter. The other point I would make as far as, again, as far as the defendant being prejudiced, this isn't evidence that I anticipate introducing in the first day, the first week, or probably not even the first month of trial. So whatever time counsel needs in order to retain an expert, run that by an expert, run that by one of their experts they already have, I don't know that, whether or not they have any experts, because again, I don't have anything from them. So as far as ample time, I would submit that there's more than sufficient time once the report is received for counsel to make use of it in whichever way they deem appropriate. And for that reason, and I'm certainly not asking the court to continue the trial date. But for that reason, I would ask that the motion to exclude be denied, absent any prejudice to the defendant.
All right, so I'm going to take this under advisement. And I may as well tell you that the best way, I think, for us to proceed with the rest of these motions is because they were filed.
All right, so that's, she's just going to take it under advisement, and eventually she'll rule on all these things and probably deny the defense most of the stuff that they want. Let's see what else I have for us. Transitions. Here we go. From the hair to bad character evidence. So the defense has another motion now to exclude bad character evidence. And we're going to watch that in 1 second. This is going to reference something that they call the Aruba incident. And that is, it'll be explained, but they are on a trip in Aruba and a situation occurs where it appears John might be, I don't know, flirty with some girls at this Aruba trip. So let's see what happens.
Character and propensity evidence. So I'll hear whoever's arguing that for the Commonwealth. The Aruba incident, if you will. I mean, I'm sorry, who's arguing for the defense? That's what I'll hear from.
I am, Your Honor.
Okay.
Thank you.
Did you say 282?
283.
282. Affidavits, 282.
Oh, this is all backwards. Pauline did this for me. All right, thank you.
Thank you.
Way to call out Pauline.
Thank you, Your Honor. The Commonwealth seeks to admit irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence against Ms. Reed by admitting inflammatory evidence of an event that purportedly transpired in Aruba on December 31st, 2021. As the court knows, this type of propensity evidence is extraordinarily prejudicial and serves no purpose other than to assassinate Ms. Reed's character in the eyes of the jury. The Commonwealth has put forth no reliable evidence to suggest that the incident that occurred in Aruba on New Year's Eve has anything whatsoever to do with O'Keefe's death, or that this remote and isolated incident was even a point of contention in their relationship at the time in question. And we aren't left guessing, Your Honor. All of the witnesses who were present at the Waterfall Bar and Grill on January 29th, 2022, along with high-quality video surveillance footage from that night, established that Ms. Reed and Mr. O'Keefe were happy, they were in good spirits, they were getting along. There is no evidence to suggest that this incident had anything to do with the facts at issue in this case. The Commonwealth points to purported angry voicemails left on the decedent's voicemail to suggest that there was some sort of hostile relationship between Ms. Reed and Mr. O'Keefe that night. However, these voicemails were left after Ms. Reed dropped O'Keefe off at Brian Albert's residence and after he failed to come back outside to meet her. There is no logical relationship between the prior bad acts evidence in this case that the Commonwealth seeks to admit and the crime charged here, and therefore this evidence must be excluded.
Okay, Commonwealth.
Yes, Your Honor. So this also relates to Commonwealth's motion to eliminate number 20.
Yes.
So in regard to that, Your Honor, this is highly relevant evidence as it pertains to motive and as it pertains to the nature of the relationship between Mr. O'Keefe and Ms. Reed, which goes to motive, it goes to absence of accident, goes to motive, absence of mistake. And this is not a, as the defendant seems to continuously try to pose it as some sort of temporary or isolated incident. This isn't just the argument or the yelling of swears between the defendant and Ms. Sullivan in the lobby in Aruba. This then leads to an argument which both children indicate in their statements continued inside the room in front of them for about 20 minutes after it happened. This is also not a fleeting reference in the sense that the defendant continuously brings it up on her own. Specifically in text communications with Mr. Higgins when she's talking about the nature of their relationship. And it's not just the voicemails that the defendant leaves on Mr. O'Keefe's phone after the murder occurs in front of 34 Fairview. It's also text messages exchanged between the two of them in the days leading up to that, in which they discuss the nature of their relationship. You also have statements from the children which indicate that the victim had tried to break up with the defendant multiple times in front of them, asked her to leave the home, and she refused. You also have a text communication from Mr. O'Keefe to Ms. Reed in which he indicates that he thinks that their relationship is essentially
What was the date of that one?
I believe that was the 28th. Then there's other text messages from the defendant to Mr. O'Keefe referring to their relationship between themselves and with the children as toxic. These are further statements regarding infidelity which continue on to the morning of, in which statements that she makes in the backseat of the vehicle with Ms. McCabe and Ms. Roberts as they're looking for Mr. O'Keefe just prior to locating his body on the front lawn of 34 Fairview. These are statements regarding her belief of Mr. O'Keefe's infidelity that she repeats again when she's having her recorded interview with Ms. Voss from Boston Magazine. These are not isolated statements. These are not just one time 4 weeks prior. It's not too remote in time, and it does show sort of the nature of the relationship and as it's evolving over the course of that month from the date of the incident in Aruba all the way through until the date that Mr. O'Keefe is killed. In furtherance of that, also, there are statements that the defendant makes to paramedics when she's being treated on scene that the last time that she saw Mr. O'Keefe, they got into a fight or an argument, and she's upset because that's the last time that they spoke was during the course of a fight or an argument in front of the house on Fairview Road. So it literally continues from the Aruba incident all the way through to the murder's occurrence. So for those reasons, the Commonwealth would submit that it is relevant as to motive, it is relevant as to absence of accident, and it is relevant as to absence of mistake. Thank you.
All right. What I will need is exactly what the Commonwealth intends to introduce. I think you've outlined it, and I'm familiar with it. If I admit it, it would certainly be accompanied by very strong curative instructions, which you know is my right. I've heard argument now. I'm going to think about this and maybe decide it by this afternoon, but...
Okay. Thank you.
Okay. All right, so you were both in agreement on what's the defendant's motion to exclude irrelevant and prejudicial evidence regarding alleged harassment and or...
That was the harassment order with, what's his face? Carney, Aiden Carney. She pronounced Kearney, which is wrong. All right. I think this is the last, one of the last motions we're going to hear from the defense. There's one at the end that I'm saving. We'll get to that, but so Karen wants to, or, you know, Karen Reed's team wants to exclude the
from the hospital for the alcohol levels.
Pause. All right. So Karen obviously would like to exclude the blood alcohol test that was done. It was done basically, so I don't know if you guys are familiar with how she got back to the hospital, but someone told law enforcement that she told her dad she wanted to self-delete, and obviously with some kind of concern like that, they'd want to put her under some kind of surveillance or something. Well, she got, somehow because of this, she was taken to the hospital right away because of that statement that someone said she said. So it's hearsay, and we don't even know if it's true, but she got taken to the hospital through law enforcement, basically without her consent, and had to give a blood alcohol test while she was there. So, as part of the Commonwealth's faulty investigation, they lured her there. Somebody lured her there, and then they got this blood sample. When they took it, it's also after 6 a.m. after they found him. She was drinking at midnight, last at midnight that we know of, or maybe she went home and drank some more after she dropped John off. We don't know. So, whatever the case may be, regardless, it's many hours later, at least 6 hours later, probably closer to 7, where they're trying to do a blood alcohol test, and how can you determine? They give a difference of like this huge range of difference of what her blood alcohol could have been, and I don't know how that's scientifically accurate, but let's find out.
Thank you, Your Honor. I'll be addressing this with the court's permission. This is number, just so we keep it clear in my head, I had named this number 17, dealing with the retrograde extrapolation.
Okay, we don't have it as 17 anywhere.
I thought that was the list that the helpful list that the Commonwealth.
Oh, okay,
Right.
Our number is 289.
Right, okay, so.
And the Commonwealth's one paragraph response is 17, but you filed the motion, so why don't we hear from you as the moving party?
Thank you. So the Commonwealth wishes to have Ms. Reed's retrograde extrapolation records admitted over, naturally, a hearsay objection, because the Commonwealth, their position is that they are medical records. The Commonwealth misapprehends the definition, the base definition of what a medical record is. A medical record, as the court well knows, holds a very special place in the evidence code, and that's because it's not compiled in anticipation of litigation. And for that reason and that reason only, they're deemed non-testimonial and not subject to Crawford and the defendant's right to confront and cross-examine witnesses or the experts behind the reports. Medical records are different than what we have here. The extrapolation records we have here are not medical records that were generated for treatment or Ms. Reed's medical history. They're the opposite. Those records were generated specifically in anticipation of litigation and in association with this criminal investigation. Thus, they are rank hearsay. The Commonwealth claims that the records are not produced in anticipation of litigation, stating basically that during her hospitalization, law enforcement was at the, quote, beginning stages of their investigation. But what the Commonwealth fails to mention or address is that at approximately 6:30 a.m. on a dash cam video, an Officer Good, as a matter of fact, a Canton police officer, states to Detective Lank that he is going to, quote unquote, section her, which the court knows what that phrase means. He's going to place a hold on her medically. Thus, the clear intent of law enforcement hours before the blood draw was actually taken was to keep her under law enforcement's thumb.
Exactly.
As she was an immediate suspect. But there's a bigger issue, Your Honor, and that is that the parties lack the essential, and by the way, this goes to the Commonwealth as well, the Commonwealth, but more importantly, the defense, we all lack the essential information on how the blood was actually drawn and tested. Those standardized protocols that we all get used to in the average OUI case, drunk driving case, they don't exist here. The standardized protocols for reliable testing, they're tried and true, and every one of those protocols is missing, or are missing, and that leaves the defense having to sort of guess at the validity of the underlying test, and the validity of the underlying test is the foundation on which the extrapolation is made, which is the only thing the Commonwealth really cares about. They don't care about the underlying test, they care about extrapolating backward several hours. But this sort of goes along the theme of garbage in, garbage out. If the underlying test was not valid, or it can't be proven to be valid, then, of course, the extrapolation is also invalid. The question remaining is, was the testing done by gas chromatography? Was it enzymatic testing? We don't know, and we'll never find out. We don't have reports to suggest that, or exactly what the validity of those tests were. So the initial result is suspect, and by extension, the extrapolation is also suspect. It bears pointing out, Your Honor, and this is the only sort of granular detail I want to get into, the extrapolation, according to the Commonwealth's expert, is somewhere between 0.13 and 0.29 blood alcohol concentration. That is a swing of more than 123%. In other words, the swing of the extrapolation is larger than any one of the numbers themselves, which means it simply cannot be reliable.
Exactly.
It illustrates the invalidity of the underlying serum plasma test, and for those reasons, the defense objects to the admission of both the blood test, the underlying test, as well as the concomitant extrapolation.
Okay, thank you. Commonwealth?
Your Honor, so what the Commonwealth would submit is this may have been a valid basis for a motion to suppress, but it was a motion to suppress that was never filed, and one that the defendant specifically waived, that Mr. Yannetti waived all motions to suppress. As it pertains to Mr. Roberts from the Office of Alcohol Testing's testimony regarding the serum conversion and the retrograde extrapolation, the reason for the range is because it's math, and essentially taking into account a number of different variables. That is why the range is as it is.
Because of math. The reason it is the way it is because of math. That was his explanation, and that's all he gave. The rest after that didn't make any more sense.
As it pertains to
Lally.
the specific item that would be introduced into evidence, meaning the defendant's medical records, that's what the Commonwealth is referring to as the records coming in. Mr. Roberts would come in and testify as to his own analysis, his mathematical calculations, and the results based on his training and experience, which the defendant has had for over 2 years, as Mr. Roberts testified at the grand jury to that exact set of scenarios. As it pertains to the testing itself, the Commonwealth, as indicated on its proposed final pretrial memorandum, has summoned in not only the doctor who ordered the testing, the registered nurse, the nurse practitioner, who would both have been involved in the taking of the sample from the defendant pursuant to her medical treatment and medical diagnoses, as well as the director of the lab at Good Samaritan Medical Center, who would testify as to what kind of testing is done and the nature of that testing and everything else. As it pertains to those witnesses, if the defendant wishes to conduct some sort of voir dire prior to the testimony in front of the jury, I certainly have no objection to that. But any sort of voir dire of Mr. Roberts or exclusion of his testimony would be inappropriate based on the fact that the defendant has had more than ample notice as to what the parameters of that testimony would be. So as far as what would be coming in as an exhibit, it would be the medical records with that amount in it, and there would be testimony from essentially anyone and everyone involved in the ordering, taking, and analyzing of that particular sample, which then provides the basis for Mr. Roberts' testimony.
Okay. So I have like one small paragraph from the Commonwealth on this. I want a memo on this.
Sure.
All right, so I'll take this under advisement.
And 17. And they're 17.
Yeah, there's 17 we still need to address some of.
All right, well, that's the majority of that. All right, so we're going to skip now to the next one, which is, so now we're moving on to the state's motions. The state filed so many motions. I'm not giving them all to you, but they did. They filed a whole heck of a lot of motions. I couldn't even keep up while I was taking notes. So I'm going to give you the main ones that I think are worth mentioning. So the first one up next is the state's motion to eliminate the manner of death on the death certificate because the medical examiner determined the manner of John's death was not, they were unable to determine it. Not able to determine. So, the Commonwealth wants that out because it doesn't go with their narrative that he was hit by a car or that it was homicide. So the Commonwealth wants to hide the truth about John's injuries, which are undetermined, I guess. So with that note, let's move to this motion. Sorry, I gotta grab my links and da 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 da. I can only do one thing at once. I cannot do two things at once. I just cannot. All right, so that's loading. Let's go over here.
From the hospital for the alcohol levels.
It didn't paste. Oh, nope, that's not it. Okay. Do I have the wrong link? Oh. Oh, thank goodness. Here it is. It just didn't copy. Here we go. This is the motion to omit the death. Manner of death.
So, Your Honor, this is the Commonwealth's motion to preclude reference and redact the manner of death contained on the victim's death certificate. This is a routine motion the Commonwealth files in really respect to any case. Manner of death.
That's not persuasive, so go ahead.
No. I'm just manner of death as elucidated in the motion is not something that is typically something that is permissible to be testified to from anybody to the jury, because that's sort of the question of liability ultimately that is left to their discretion as far as how they find the facts. But cause of death obviously is something that is a medical determination. Manner of death, as the court is well aware, is there are essentially 3 or 4 different selections, and they fall into different categories. They don't necessarily mean in the medical context what they might mean in the legal context. So for that just sort of simple differentiation of meaning between the two, manner of death is not something that the Commonwealth feels is appropriate for the court, for any witness to be testifying to as far as the jury is concerned, as that's a question for them ultimately to determine. And for those reasons, the Commonwealth would ask that this motion be allowed.
All right, who's responding to this?
Thank you, Your Honor. The medical examiner who completed the
One quick thing I just want to interject. So the cause of death is the underlying medical condition, disease, or injury that begins a lethal chain of events resulting in one's death. The manner of death describes the way in which a death occurs, which may be homicide, suicide, accidental, natural, or undetermined. And in this case, John's manner of death was undetermined. So his cause was hypothermia and blunt force trauma. And so the manner, it was undetermined. So you can't say that it was homicide, but yet you want to put Karen behind bars for the rest of her life because of a homicide. But you can't say definitively that it was a homicide. I think that's a problem.
death certificate, in this case, concluded that the manner of death was undetermined. The Commonwealth now seeks to have that portion of the death certificate redacted because it is quite clearly exculpatory. All of the cases cited by the Commonwealth deal with the issue of whether it was error for the Commonwealth to admit a death certificate listing the manner of death as a homicide, because it violates a defendant's right to due process and a fair trial under the 5th, 16th, and 14th Amendments to the United States Constitutions. None of the cases cited by the Commonwealth stand for the proposition that a medical examiner's determination that the manner of death is undetermined should be redacted. In fact, the Commonwealth cites Commonwealth versus Ellis at 373 Mass 1, it's a 1977 case, for the proposition that excluding the word undetermined is the better and safer course. But that's a misstatement of the law, and I would urge the court to read the Supreme Judicial Court's opinion in that case. What it actually says is this, quote, "Nothing contained in the record of a death which has reference to the question of liability for causing death shall be admissible in evidence. The better and safer course is to exclude from a death certificate the words homicide, suicide, or accident in a criminal trial." Notably missing from that list of words that the Supreme Judicial Court warned about is the word undetermined. That is what the Commonwealth seeks to have redacted here. The Commonwealth bears the burden of proof in this case. They have to prove beyond a reasonable doubt that a homicide occurred, and their own medical examiner has opined that she was unable to make that determination. That finding is relevant, it's exculpatory, and there's no authority that supports its redaction. Thank you.
All right. Mr. Lally, the medical examiner will be on your witness list, right? I haven't seen either of yours witness list.
Yeah, sure.
Okay. So I'll take this under advisement.
Under advisement. She took most things under advisement. All right. So the next part we're going to go over. The state's motion to include body cam footage of Karen Reed at the time of arrest. So let's take a look at this. Sorry, takes me a second here. Alrighty, so the Commonwealth really wants to make Karen appear guilty before, at least in the eyes of the jurors.
I'll hear you on this, Mr. Lally, and remind me the date that this body cam footage was taken.
So he's going to misquote something also, so we'll come back to that. But he's just, the only reason that you would want to include this body cam footage of Karen Reed at the time of arrest is to make her appear guilty, to make her look guilty in the eyes of the jurors before they can determine it. If you see, it's the same psychological effect. If you see a prisoner in a yellow jumpsuit, you're going to see them as, I mean, if you see the defendant in a yellow jumpsuit, you're going to see them as a prisoner. You'll view them as that because that's what their surroundings are, how you're observing them.
So, Your Honor, this is in reference to the defendant's arrest post-indictment by the grand jury in this case. So it's June 9th, 2022.
So that's why I have not seen the video itself.
Correct, and that's certainly something that the Commonwealth can provide for the court. But essentially, when she's arrested and during the booking process at the Milton State Police Barracks, the troopers who conducted that arrest were wearing a body-worn camera pursuant to their BWC policy with the state police. Counsel has a copy of the policy, counsel has a copy of the video, and essentially there are a number of different statements which provide sort of third, fourth, fifth, sixth, I'm not sure what number we're up to at this point, of sort of varying accounts that the defendant has provided to numerous people.
Can you give me an idea now? Do you know the substance?
So the substance of these particular statements is the defendant, Ms. Reed, continuously is told by Sergeant Buchanan to essentially stop talking. He's advised her of her Miranda and advised her to stop making statements, and repeatedly states that to her during the course of her making statements. But the sum and substance of it is she says something to the effect of, you know, are you in on the joke? And then makes some sort of reference to having witnessed Brian Albert and Colin Albert essentially smashed John O'Keefe's head into the taillight, indicating that that's how her taillight was broken. Doesn't make any sort of further statements about why she would then leave the scene after that occurred or anything like that. But these are, again, different accounts that have been made in direct variance to prior statements that she made January 29th to the troopers, to paramedics, to treating medical professionals, to Ms. Roberts, to Ms. McCabe, to the niece of Mr. O'Keefe, to a whole other sort of slew and variety of people with a different sort of variation on what transpired each time. So it's sort of inextricably intertwined with the fact that she's in custody.
How so? Is she in handcuffs? Is she in a cell?
She's seated at the booking desk or the booking rail in the state police barracks. So, I mean, I don't need to make direct reference to it. It's just, again, it's something out of an abundance of caution based on sort of where it is and when it is that the statements are made, that it may naturally sort of come out as far as if the court wishes. I think it's something that the court can cure by issuing a curative instruction if there's any prejudice to be suffered by the defendant. But again, it is a statement by the defendant, which is admissible, as the court is well aware. And then it is sort of in the confines or in the context of her being in custody when she makes that statement. I certainly wouldn't be trying to elicit testimony that she was in custody, but it is kind of apparent that she is.
Can you have that here for this afternoon
Yes, I can arrange for that.
so we can see it?
Sure.
All right, what's the defendant's position here?
We object. Your Honor, we're in a situation now where the Commonwealth arrested Ms. Reed twice when they didn't have to. I made the argument to you at arraignment back in June of 2022 that after John O'Keefe was found dead on the lawn of Brian Albert's home, I immediately got a letter out to the state police saying, I represent her, I will surrender her, no need to arrest her, just call me and I'll bring her in. They ignored that and they arrested her to get her into custody. I would assert ultimately to make the arguments that Mr. Lally's making today. Then, astonishingly to me, after the grand jury issued indictments, based on basically no new evidence, they upcharged her and once again did not contact me, despite the fact that she was completely in compliance with the terms of her release and had made every court appearance. They arrested her again. And so, again, I would assert to be in the position that they are in today. With regard to the case that they cited, Your Honor, Hoffer does not stand for the proposition that they claim that it does. In fact, the issue of that defendant being taken into custody was stricken by the court. The testimony in that case that was allowed or sanctioned by the SJC was evidence that the defendant had been living with his girlfriend but had unexplained absences. He didn't get along with her son. She was afraid of him, and that he associated with a convict that made her nervous. There was nothing about him being in custody that was admitted in that case. To the extent that these statements are, or the court deems these statements to be relevant and admissible, there are other ways to do it. I do urge the court to watch the video.
Yeah, I think we'll put it on the screen because I want to see how the jury would look at it.
Okay, that's fine. But I will suggest, Your Honor, that there are other ways to accomplish that, you know, either to have testimony about what it was, or failing that, to have the audio of my client making whatever statements they seek to introduce without the video. An image of my client, you know, in handcuffs at a police station is what this court generally tries to avoid, given the fact that as she sits here and as this trial is ongoing, she's presumed to be innocent. We wouldn't bring her up here in an orange jumpsuit and then ask the jury to make decisions about her, nor should we display her you know, after a perp walk at the police station in handcuffs, making these statements.
All right, so I need the Commonwealth to, do you have your media person available, Ms. Gilman or Ms. Crawford or whomever?
Yes.
All right,
We're seeking to make arrangements for that.
All right, we'll put it on the screen just so I can see how the jury would see it. All right, thank you. So we'll look at that this afternoon.
Okay, so that is their first arguments about this video. So we're going to come back to the afternoon. So, hold on. first, we're going to listen again to what Lally had to say. Adam Lally is the prosecutor in this case. So we're going to listen again. What he said, Karen Reed says in the video. Then we're going to watch the video.
The substance of these particular statements is the defendant, Ms. Reed, continuously is told by Sergeant Buchanan to essentially stop talking. He's advised her of her Miranda and advised her to stop making statements, and repeatedly states that to her during the course of her making statements. But the sum and substance of it is she says something to the effect of, you know, are you in on the joke? And then makes some sort of reference to having witnessed Brian Albert and Colin Albert essentially smashed John O'Keefe's head into the taillight, indicating that that's how her taillight was broken. Doesn't make any sort of further statements about why she would then leave the scene after that occurred or anything like that. But these are, again, different accounts that have been made in direct variance to prior statements that she made January 29th to the troopers.
Okay, so we heard what he thinks she says. Let's actually watch the body cam and see what she actually says in reality.
To paramedics, to treating medical professionals, to Ms. Roberts, to Ms.
So we locked up the house. The back door, we just did the lock.
Okay. Can you explain to me what the process is right now?
Absolutely. So you're going to be booked just like last time. Go through the same process. It's going to be a little less time consuming because we're not going to do major case prints because we did those last time. Once you're booked and you go through this portion of it, we'll let you make a phone call just like last time. We'll make a phone call. Your parents will be able to bring you whatever other additional need, things that you need.
Yeah.
And then tomorrow morning, you'll go and be arraigned at Norfolk Superior Court on the charges that were. I'm sure he'll go over the charges again with you on the warrant.
But I'm on bail, so how can I be spending the night here again?
All right, so I'll explain that portion to you, as long as it's not going to interfere with you. Are you ready to go?
Yeah, I'm just waiting for Rams to.
Okay. So initially, your arrest was on probable cause out of the district court. Okay. So the charges that you were arrested on initially were out of district court, out of Stoughton District. That's where the arraignment was. It was district level charges. Today, grand jury indicted you on these charges, which is second-degree murder, vehicular homicide, and leaving the scene of a death. Okay, so those are the charges that grand jury indicted you on. So now you're being charged and will be arraigned in Superior Court, Norfolk County Superior Court in Devon. Okay.
So the bail doesn't apply anymore?
Typically, I'm not, so we don't set the bail, but typically once murder comes into play, people are going to get bailed out.
So it's not manslaughter anymore, is that the difference?
That's correct. It's a higher degree of taking a life. Okay, so that's the charges that you're being charged with now, and you were indicted by grand jury.
Okay, you're aware he was beaten up by Brian and Colin Albert. I mean, we're all in on the same joke, right? My taillight was cracked and John was pulverized.
Okay, you need to abide by the rights that were afforded.
All right, so let's hear that again. What did she just say? Go backwards a little bit here.
Taillight was cracked and John. We're all
By grand jury.
Okay, you're aware he was beaten up by Brian and Colin Albert. I mean, we're all in on the same joke, right? My taillight is cracked and John was pulverized.
Okay, you need to,
My taillight is cracked and John's face is pulverized. Are you aware, or you are aware, that he was beat up by Brian and Colin Albert? We're all in on the same joke, right? His face was pulverized. Yeah. So, from the start, she has been saying this was not her and it was somebody else in that house doing it. It's interesting that it is Brian and Colin Albert. You know what? I'll save that thought till we get to that part. But anyway, so isn't that interesting that Adam Lally lied in court? He absolutely lied in court. All right, so what does she say? Let's let it play out the rest of the way, I guess, and then we'll go to the next one.
abide by the rights that were afforded to you, okay? So you can talk if you want. If you want to tell us what happened, that's fine, we'll listen, but you were ready.
So this is the first time he's saying you can talk if you want.
Rights, okay?
Oh, but you were read your rights. Okay.
And I'm sure he's going to do it again. All right. If you want to talk to us, you want to give us a story, definitely. We'll take it.
No, I don't. I mean, I know you already know the story, so I don't need to.
All right. How long is the entire tape?
So that is Trooper Pye, who was the arresting officer from the barracks. So it goes, I believe, at least 90 minutes or so.
All right. Do you have the entire, we're not playing it now, but do you have the entire video? All right. I would like it marked for identification.
Sure.
I'd also like a copy of it so I can view the whole entire thing, put it all in context. I never like to see just sections.
Sure.
Can I get that for the weekend as well?
Oh, absolutely. And for the record, as far as I think a lot of that sort of preliminary stuff was more meant as context for the court. You know, there's certain discussions about court procedure and things that I don't think should be put in front of the jury.
All right, so that was my concern as well. Okay, so
I don't know what is happening with my logo here. It's like moving ever so slow. I try to move it to cover the other logo. Okay. No. We're just being real friggin' slow right now. Hold on. There we go.
so it's something I'll watch a few times, and the whole thing as well. Okay. All right. Thank you.
Thank you, Your Honor.
For identification. Thank you very much.
So again, she's just taking it under advisement. Everything she's just taking under advisement. She's not really making many rulings. There were a few motions she made for the Commonwealth that she agreed to on the spot, which were insignificant ones. Just to recap, the state wanted... they want to be able to use leading questions for the minors in this case, which is John's niece and nephew, and she allowed that, which you're not supposed to lead witnesses with your questions. And also they wanted to have the jurors' responses verified. So they want to make sure that the jury isn't tainted and there isn't someone on the jury to like be there just to, you know, make everybody vote not guilty or something along those lines. They feel like they can't trust the system, and that's really dumb. But she allowed that, so all the jurors are going to have to go through some kind of verification process. I don't know what. They also wanted a Cellbrite expert to demonstrate something within the courtroom regarding some kind of demonstration for, I believe this is for the 227 House Long to Die in Cold guy. So he might, or not, well, Jen McCabe is the one that texted it, but I think that they're calling it an expert to the stand for that purpose. But let's move on to this next one, this next motion, the state's motion to omit references to the federal investigation. We all knew this was coming. They don't want any references made to the federal investigation because, oh, guess what? The feds are investigating them. So they want to hide their own misconduct and corruption by not allowing conversations about this topic, the federal investigation, the federal letters, nothing. And you know what? Oh, sorry guys. Something, I think the mailman or something got delivered. I don't know. And of course, all the doggies wake up from their naps and have to bark really loud. And I apologize. All right, so Karen, back to this Karen Reed, the Commonwealth motion. So no references to the federal investigation is what they want. And it's, so basically anything regarding like people being subpoenaed to go and testify for a grand jury, any talk about that is not going to be allowed in if she approves this or allows this motion. So let me get our let me give it the link ready. Oops, shoot, hold on one second. Dog, can you go lay down? You're just standing there staring at me. I have nothing to do with the mailman. All right, she's mad at the mailman.
And or the Federal Bureau of Investigations. So to this point, the U.S. Attorney's Office has publicly confirmed that at no time has the U.S. Attorney's Office named any person or entity as a target. So any sort of reference to, and essentially what they've stated throughout the course of, and I know the court has had a chance to review those materials, but what they state is essentially their investigation into some unnamed criminal activity or some unnamed crime or some, there's nothing specific to any specific person or entity that is contained within those materials. So what the Commonwealth is submitting is that any reference to the fact that those things occurred is therefore unfair, essentially biases against one side or the other based on that, and it really has no relevancy. As far as making reference to, if counsel at some point, either side, wants to make reference to testimony or statements, reports, things of that nature that were provided in the course of that discovery pursuant to the TUI, obviously that's perfectly permissible, but it also can be done without making reference to where that item came from. As far as you testified previously in relation to some investigation on such and such a date, you spoke to a law enforcement agent on such and such a date and you said this. So if it's needed for those kinds of reasons, as far as impeachment and whatever, that's obviously perfectly permissible, but any reference to that in front of the jury, Your Honor, is something that the Commonwealth would submit is simply impermissible and irrelevant to the facts as they pertain to this case. So for those reasons, the Commonwealth would ask that this motion be allowed.
Is there an objection to this?
There is. Your Honor, the Commonwealth's position can be basically summed up in their moving papers with the following sentence that they drafted. The proceeding would be unfairly prejudiced if the defendant is permitted to rely on the mere appearance or existence of a federal investigation, especially where the investigation was shaped and influenced by the defense. First of all, the defense does not and did not shape or influence any federal investigation. The federal government is more than capable.
The Commonwealth is blaming the defense for the FBI coming at them. Really. Really, if you weren't corrupt, maybe they wouldn't come at you. And by the way, they were probably already investigating you because of the Sandra Birchmore case, which happened prior to this, and very, very, very corrupt people were involved, including Michael Lank, who we're going to be talking about in a little bit. So don't go anywhere.
Capable, Your Honor, and I think the Commonwealth knows this, of making its own decisions and about its own investigations. Second, and just as importantly, the Commonwealth cites no authority whatsoever that stands for the proposition that the mere mention of a federal investigation prejudices state court proceedings in any way, shape, form, or fashion, and that's because there is no authority. That authority does not exist. But most importantly, and this is critical, it is going to be critical to give the trier of fact, this jury, the proper context in which every one of the statements or every bit of the evidence is presented and how it came to light. It's essential for the jury.
How are you going to do that? How do you propose? Is somebody from the U.S. Attorney's Office on your witness list to come in and talk about it?
There are federal agents. No. We don't anticipate presenting the fact that there's a federal investigation.
Isn't that what this does? If you mention it,
no. What this does,
explain to me why that's not so.
That's what I'm doing.
Not yet. You haven't. So please.
Oh my God, she's so rude to him. Like, for no reason. She just wants to be rude to Alan Jackson. She does not like this California boy coming into her courtroom and showing her up. She does not like it. Let's hear that a little exchange again.
Isn't that what this does? If you mention it,
what this does,
explain to me why that's not so.
That's what I'm doing.
Not yet. You haven't. So please explain that.
As the court knows, it's essential that the jury is given the context in which every single statement, whatever the statement might be, is brought to light.
Does that mean, do we say in the prior trial that resulted in a mistrial, you said this?
No, but you would say when you were speaking with Officer Smith or Officer Jones from the Canton Police Department at the Canton Police Station in this particular context, did you say this? When you were questioned by the Commonwealth's attorney in this proceeding, did you say this? When you were questioned by the United States attorney in this hearing, did you say that? That's what we do.
Yeah.
Otherwise, it's perpetrating a fraud on the jury. The information that's gleaned during the federal investigation was revealed, Your Honor, importantly, by a neutral third party. A neutral body that's not connected in any way to this case. The Commonwealth has a stake in this case, very obviously. The defense certainly has a stake in this case, but the federal authorities have no stake in the case of the Commonwealth versus Karen Reed. Thus, the evidence procured by that neutral agency, which is independent of the case, is subject to a different and completely different level of scrutiny, a completely different level of assessment by the jurors. That is an important fact. There is no other way to truthfully and honestly present this evidence to the jury. Think about some of the questions that the court just posed. What were the circumstances in which you changed your testimony, sir? He's going to say, well, I changed my testimony, potentially, when I was called before a federal grand jury and I was asked questions under penalty of perjury. Why did you finally admit certain things when you were confronted with additional evidence, ma'am? And where did that evidence come from? Well, I was called before a grand jury and I was asked, or I was interviewed by a federal agent and I was asked or confronted with additional information, text messages, phone calls, etc. Or the third example, where did that additional evidence come from, officer? Text messages, phone calls, private communications. Oh, it came from a hearing in which I was questioned by a United States attorney under penalty of perjury in front of a grand jury. The jury's entitled to those answers in that context. If we were to do what Mr. Lally suggests, if we were to take that invitation, oh, well, you were asked by a prosecutor at a former hearing, XYZ. That would leave the jurors with the imprimatur of the idea that the Commonwealth elicited those questions, that the Commonwealth did their job, when we know, in fact, it didn't. The answers to those questions directly go to Ms. Reed's Bowden defense. Bowden talks about the inadequacy of an investigation. Obviously, Mr. Yannetti can talk more about that in just a second. We have information that a different agency was able to uncover information that the state investigation ignored. That's important. And it's important for the jurors to be able to weigh and balance that information and how the information came to light. If the truth is actually hidden from the jury, which is what the Commonwealth is asking the court to do, that the evidence was produced by was the product of a third party, the truth being that the evidence was the product of a third party inquiry, unconnected to the state court case, then that jury is left with a false impression, false information, and it'll be unable to properly assess the true facts, which is what we're trying to get to, the true facts. Why is the Commonwealth so intent on hiding the truth from this jury? I'll submit.
Okay. I'll likely rule on that today. So, number 28, Mr. Lally.
Sorry, I don't know if she has ruled on these. I have to check all my sources. I haven't gone through all of them yet at the time of this recording, so I apologize, but I'll give an update. In fact, I've really been going back and forth as to whether I should stream the entire trial or like stream it all day long live, or should I do a like a recap daily. And honestly, with my autoimmune disease, I think I'm probably just going to do a daily recap. Let me know in the comments, please, below if you would really like me to go live, or if a daily recap is good. I'm sure going to be a lot of people streaming it live, so I want to add to it and, give you guys my feedback as we go, but I think we could probably do that in like a daily update every evening. So let me know in the comments below what you guys think. I don't think I'm going to have the energy to do all, 8 hours of streaming or however long it's going to be. So we'll see. I think I'm just going to do daily recaps for now. But if you guys feel very strongly that I should do lives, please let me know in the comments below. All right, so let's get to this next one here. So we're going to do...
Similar to the motion
similar to the last motion that we just heard, we're going to hear this next motion, which is state's motion to exclude misconduct of Sgt Lank and Trooper Proctor. So also there's internal investigations being done on Proctor. I don't know if there is one on Lank, but there probably should be. And we're going to talk about him. Again, don't go anywhere. We're going to read some interesting stuff after we go through all the main points of the hearing. So we'll definitely, you'll want to stick around for that. So, all right, so the state's motion to exclude misconduct of Sgt Lank and Trooper Proctor. Again, it's another case of the Commonwealth just wants to hide all of the misconduct that is happening in this case, and the poor investigative work, the terrible law enforcement, the abuse of power of the law enforcement that has been done in this case. And they want that out. How can you rule on that, like, honestly, and how can you allow that to be excluded? I don't know, but here we go.
Previous to it, the Commonwealth is not seeking to hide anything from the jury. What the Commonwealth is simply seeking to do is ensure that whatever information that's provided to the jury is actual admissible and relevant information, and not the product of rank speculation. So this motion is seeking to prohibit reference to any pending internal affairs investigation or unfounded allegations of misconduct. And really, primarily what we're talking about here is any sort of internal affairs investigation related to Trooper Proctor and the 20-something-year-old civil case which resulted in no findings of liability that was referenced by counsel in their motion to dismiss with reference to Sgt Lank of the Canton Police Department. Under the case law, including McFarland and Graham, the most recent case law, what they essentially attribute is that those types of information, when there is no finding of liability, there is no sustained finding of misconduct, there is no findings of liability by the party at question, that is simply not admissible. And so for those reasons, the Commonwealth submits that this motion should also be allowed.
All right, who's arguing this for the defense? And Ms. Little, what I need to know is what exactly you intend to introduce and how you intend to introduce it.
Thank you, Your Honor. I think it's somewhat premature for the court to rule on this issue. Obviously, the testimony of both of these witnesses is going to be highly relevant as to whether this particular information is relevant. We are still actually receiving information with regards to the internal affairs investigation as recently as yesterday. So I'm happy to kind of defer ruling to the court and then address this as it comes up. I think the court will be in a much better position to rule on this issue once the witness testifies.
All right, so what would be helpful to me, once you know what it is you think you're going to try and introduce, to tell me how that complies with the holdings in both McFarland and Graham.
There are independent reasons why that is admissible outside of McFarland and Graham.
Okay, so I need to know all of that.
Sure.
Okay.
Thank you.
So I'll take this under advisement. And how much time do you need to give me at least a general response now? Can you have it by Tuesday?
We can do that, Your Honor.
Okay. All right, so I'll hold.
All right, so she's just putting that or taking that under advisement again. All right, so nothing ruled on for that right now. Next, yeah, like I said, don't forget to stay tuned. We're going to go over the Mark and Alfredo Lopilato or Lopilato complaint against Sgt Lank and what he has to say about him. All right, so up next, we're going to talk about, this was the biggie. This was the bombshell, the big bombshell. So Karen's right to defend herself. Third-party culpability. Everyone has a right to defend themselves and to say it wasn't me, it was someone else. Everyone should have that right. The Commonwealth filed a motion to basically block Karen from being able to use any kind of third-party culpability, which is just a total dick move, if you ask me. So there's going to be a couple parts, clips that I'm going to play. So let's get the first one up and ready.
I'll talk about how exactly we'll go through them in a minute. But first, so in reviewing the motions in limine, I mean, clearly the defendant has an absolute right, a constitutional right, to present a third-party culprit defense, but counsel is well aware that that is not without limit, right, from the case law. Now, the defendant has stood here, defense counsel has stood in this court repeatedly, stood here and in other venues and in their pleadings.
I just want to say that this is exactly how the whole hearing started. I'm playing things out of order because I wanted to show you things together in, a way that I wanted to present it. If you are very curious, you can go watch the whole thing on your own in an order, but I'm picking out the big pieces and just showing you the important stuff. So this is, like I said, this is how the hearing got started. First, her just basically reprimanding and talking down to the defense about this third-party culpability defense that she has every right to have. And Judge Cannone is entirely wrong in what she's saying. So let's back it up a little bit to hear where she goes a little sassy.
That is not without limit, right, from the case law. Now, the defendant has stood here, defense counsel has stood in this court repeatedly, stood here and in other venues and in their pleadings, espousing various third-party culprit theories or scenarios. But now that it's time to actually try the case in the courtroom, I don't have a motion from the defense to admit third-party culprit testimony. So, and as you're well aware, I have to make findings before any mention of any third-party culprit evidence or even an opening goes before the jurors. You know, in order to admit it, and given that I have no information at all, I mean, I don't know who the third-party culprit is, even after reading 4,500 pages of discovery. I don't know what motive a third-party culprit might have. I don't know how it's relevant. I don't know if it's remote or if it's current. I don't know if it's speculative or if it's relevant. I don't know if it will prejudice or confuse the jury. And if it's hearsay, I have a whole other series of factors I have to consider. So, Mr. Yannetti, are you pursuing a third-party culprit defense?
We are, Your Honor, and I'm prepared to address that. The Commonwealth has raised the issue, and I am prepared to address that today.
So you filed your motions first, and you did not raise it. So if the Commonwealth had not raised it, you did not move to introduce it, correct? I have no motion from
No, I
from
understand.
you about it.
I understand, Your Honor. If you'd like something in writing for us, we can do that. I have a full argument prepared.
All right, so who is the third-party culprit?
We are under no obligation to name any specific third-party culprit.
How am I supposed... So you're prepared to argue all
Hear that again.
the third-party culprit?
We are under no obligation to name any specific third-party culprit.
How am I supposed... So you're prepared to argue all this?
I'm prepared to argue it, Judge.
All right, so we will get to that when we get to the Commonwealth's motion.
That's fine.
Now, the second thing I want to address, because...
Okay, so that is where I'm going to leave that clip. Just that's how the whole hearing started, with all of that sass. It's very very interesting and very telling how this trial is going to go. I really believe that she's not going to be very fair when it comes to Karen's team here. Here's the next clip about her third-party culpability defense.
All right, so as you know, third-party culprit and Bowden are often argued together, often presented together. Why don't we just deal with the two motions together? So, Commonwealth's file, you're number 30 and 31, Mr. Lally. Mr. Yannetti, are you arguing both? Does it make sense to sort of keep them together?
I agree that they should be kept together.
Yeah. All right, so why don't I hear you as to your concerns on both, and as you know, sometimes third-party culprit as it goes to Bowden is different than just straight third-party culprit. And actually, it might save us a lot of time. Is that what you intend to do, Mr. Yannetti, third-party culprit as it goes to Bowden, or straight third-party culprit as well?
Definitely third-party culprit as it goes to Bowden, that's for sure. And then depending on how the evidence develops at trial, there may be, you know, an offer to offer third-party culprit evidence with regard to third-party culprits. But I think I can speak further to that in response.
Mr. Lally, go ahead. You can argue these however you want to argue them.
No, and I would argue them sort of in that vein, Your Honor. So understanding that based on the state of the evidence, as I anticipate it to be, and in any case, regardless, I think a defendant in any criminal case has a much better shot, essentially, at getting evidence in regarding to Bowden as sort of a backdoor through, as to third-party culprit as sort of a backdoor through a Bowden defense. So what I'm primarily concerned with, Your Honor, is motion to eliminate number 30, because as the court is well aware, there have been a number of theories of sort of speculation, rank speculation, opinions without any evidentiary support, names of certain people that have been dropped at this microphone by counsel at different pretrial hearings who are not witnesses, who have nothing to do with this case, who don't know anything about this case, who counsel, when they said those names and sort of dropped those, whatever they supported to be facts, knew that they had nothing to say and nothing to do with this case. What I'm concerned about is whatever is acceptable as far as believability when it comes to arguing things in pretrial motions, shouting things from courthouse steps, or bandying about on Twitter is not what we do here. And so now it is a time where counsel is going to be relegated to what is actual, admissible, relevant evidence. And what I'm asking for in this motion is for the defendant, through her counsel, to actually provide any admissible or relevant evidence that pertains to third-party culprit, which to this point they have not done. So if this is something that's going to be raised as an issue on its own, as the court is well aware, what the case law indicates is that the acts of the other person are so closely connected in point of time and method of operation as to cast doubt upon the identification of the defendant as a person who committed the crime. It has to be specific. It has to be to at least a specific realm of person or a specifically identified person who would have motive, opportunity to commit the act with which the defendant is charged. And up until this point, I have not seen anything specific as to that. As it pertains to the Bowden motion the Commonwealth filed, what the Commonwealth is asking for there is notice and voir dire in relation to a Bowden defense. So if there is, again, going to be some, I don't think the evidence comes anywhere close to a Bowden instruction, but certainly what the courts have said over time is that a Bowden defense is something that if the evidence warrants it, counsel can elicit testimony in regard to it or attempt to and make arguments in reference to it. So I'm not seeking to preclude counsel from making arguments or from counsel asking questions. What I'm seeking clarification on is what exactly, and again, this is from a position of operating without any information whatsoever as to what a defense may be. And understanding that counsel was not required to provide any information until the Commonwealth filed its certificate of compliance. But there's been, regardless of whether they were required to or not, I'm going into trial on Tuesday without any information whatsoever as to who they've spoken to, what they're what statements they might be, who their witnesses are, or anything of that nature. So for those reasons, the Commonwealth feels it appropriate to at least file a motion to be given notice as to exactly what the defendant intends to do. This trial by ambush is simply not something that's permitted by the case law, and that's what the Commonwealth is seeking to prohibit in that second motion. Thank you.
Okay. All right, Mr. Yannetti, I'll hear you.
Thank you.
And though they're argued together, I do want you to also start with the third-party culprit alone, not third-party culprit as it goes to Bowden, but third-party culprit alone, because of all those factors that I told you, as you well know, the case law is clear, that I have to consider. And if I had to do it now, and you know I can do it pre-trial, right? You know that today I can just exclude it. I'm not inclined to do that, but
Again, this is Judge Cannone being a bitch and going like, you know I can do this. You know I have the power. What a... She is going to really make me angry during this trial. I just know that for a fact. Yeah.
I need to be able to make those decisions, to weigh those factors, because right now I have zero information on
Right,
those.
I understand that, Your Honor, and that was my plan going into today anyway. So the initial question is, why is there a third-party culprit defense? Why is it relevant? And we start, Your Honor, with the fact that our forensic medical examiner, Frank Sheridan, a pathologist, forensic pathologist who has performed himself thousands and thousands of autopsies, has already submitted a sworn affidavit to this court that John O'Keefe's injuries are consistent with having been in a fight and are not consistent with having been hit by a car. Since he submitted that affidavit, the federal authorities have provided us with their reports, whereby FBI experts also corroborate that John O'Keefe's injuries are not consistent with having been hit by a car. They employed experts in biomechanics and kinematics who have reviewed the evidence in this case, and they've confirmed that the physical evidence essentially shows and doesn't show what Dr. Sheridan has opined. So therefore, if John O'Keefe was not hit by a car, that means that Karen Reed did not kill him. And we know that John O'Keefe...
Right? So why are we still going to trial? Say that again, David Unetti. Excuse me.
So therefore, if John O'Keefe was not hit by a car, that means that Karen Reed did not kill him. And we know that John O'Keefe did not die of natural causes. This was not a heart attack or a stroke. John O'Keefe was injured. He was mortally injured. If he was not hit by a car, as both our expert and FBI confirmed, then he was attacked. And if he was not hit by a car, then there is a third-party culprit or culprits. So by asking this court to prohibit the defense from introducing evidence that others had the motive, opportunity, and the means to attack John O'Keefe, the Commonwealth is essentially asking this court to prohibit Karen Reed from being able to defend herself.
So I don't think they're asking that you be prohibited from doing that. They're asking first to have you tell them what that is.
Right. Well, this is, you know, Your Honor, I'm getting to that in terms of
right, so go ahead. You have your remarks.
That we're either required to give them or not. You know, it is not our job to solve this case for the prosecution. It's our contention. They had the opportunity to do that, but they failed. It is not our job to name a specific third-party culprit. We do not have to prove that Brian Albert or Colin Albert or Brian Higgins or some combination of them intended to kill John O'Keefe. We don't have to prove that any of them attacked John O'Keefe such that he eventually died. They have to prove beyond a reasonable doubt that they didn't. But the fact of the matter is there is evidence that all three of them had a motive, had the opportunity and the means to attack John O'Keefe. Now, the Commonwealth cites Commonwealth versus Conkey in their motion, and as this court started the discussion on this issue when you first took the bench, Conkey makes clear that a defendant has a constitutional right to argue that somebody else may have committed the crime. And certainly, no, the acts of that person can't be too attenuated in time or method of operation, as Mr. Lally mentions. But in terms of being the right time period, Your Honor, you can't get any closer than their presence at the scene at the very time that John O'Keefe was killed. And in terms of the method of operation, given that we have evidence that he was not hit by a car and that he was attacked, all three of these men, either alone or in combination, possessed the ability to attack him with or without a weapon. I mean, it's a very low standard here. The Commonwealth acknowledges that. It's a low standard of simple relevance. And the evidence here establishes relevance. Now, I would note, Your Honor, the Commonwealth cites Commonwealth versus Finney. I don't know if they realize this, but that was my case. I represented Roland Douglas Finney before the Supreme Judicial Court, and I represented him at his motion for new trial and at his retrial. And that case, the Finney case...
So in an argument about this, the Commonwealth cited this Finney case. Well, it was actually David Unetti's case. He was on this case, and he basically, like, helped pave the way for this to happen. So
provides strong support for the introduction of third-party culprit evidence here, irrespective of a Bowdoin defense. In fact, the reason that Mr. Finney's conviction was overturned was that his trial counsel failed to pursue a third-party culprit defense. And, Your Honor, the third-party culprit defense in Finney was weaker, far weaker than the third-party culprit defense we have here. The evidence of motive in that case was that the third-party culprit made derogatory statements about the victim after she was murdered. No witness in that case put the two of them together. No witness in that case put the third-party culprit at the scene of the murder where the victim was murdered. There was some consciousness of guilt evidence similar to what we have in this case. But in Finney, the SJC ruled that not only was that enough for a defense attorney to present a third-party culprit defense, but he was ineffective for not doing so. And as the court has also touched upon, the SJC found that on the basis of that third-party culprit evidence, which is weaker than what we have here, there were substantial connecting links between that third-party culprit that justified the admission of hearsay in that case. And I want to make it clear, we're not looking to introduce any hearsay statements, so we don't need substantial connecting links here. Now, Your Honor, I could go through with the court the specific evidence we have with regard to motive, opportunity, and means with regard to the three Commonwealth witnesses that I've named.
So go ahead.
Happy to do it. Starting with Brian Higgins. He was present at 34 Fairview Road on January 28th to 29th. He was close friends with the homeowner, Brian Albert. He had a prior romantic interest in Karen Reed. He did not expect Karen and John O'Keefe to be at the Waterfall, that bar, on January 28th. Karen Reed did not greet Higgins, despite the fact that they had previously exchanged flirtatious texts and that she had been at his apartment one evening, although there was nothing that took place between them any more than a peck of a kiss. At the Waterfall, Higgins does not engage with John O'Keefe. He does not say goodbye to John O'Keefe and Karen when he leaves, but before he leaves, he texts Karen, and that text was something to the effect of, well, with a lot of M's. We know that there was a preservation order from this court, your predecessor, Judge.
Basically, someone's jealous and wants Karen for himself, and that gives Brian Higgins so much more motive. And that only helps bolster Karen's exculpability? Is that a word? I don't know. Her her innocence. It only goes more towards her innocence if this guy has these unrequited feelings for Karen, and Karen keeps going back to John or whatever. I don't know the situation between them, but it does seem like Karen and Brian, at least Brian, has a thing for Karen, and there might have been a moment or two where Karen may have wanted Brian, or I don't know, in a moment of weakness went to Brian for help, and Brian, who knows, whatever. I don't know what happened, but she admits things to Brian, I guess, in text messages about her relationship with John.
Judge CvrUp to preserve his cell phone, and that Trooper Proctor gave him an edict, an order to serve on Brian Higgins, and he left it at the front desk of the Canton police station for him. And that Higgins, we learned through the federal investigation, Higgins became angry, demanded that Proctor come back, and he essentially upbraided him and read him the riot act, which shows a little bit about Higgins' personality.
So Trooper Proctor had to come back and subpoena him. He had to, because otherwise it would look bad on Trooper Proctor's part. So whatever. So he subpoenas Brian Higgins because Brian he has to serve it anyways. It's not like he requested the subpoena, he has to serve it. It's not coming from Trooper Proctor. But yeah, so Brian Higgins gets mad and that this is happening from his friend Trooper Proctor, and let's hear that little exchange just one more time.
An order to serve on Brian Higgins, and he left it at the front desk of the Canton police station for him, and that Higgins, we learned through the federal investigation, Higgins became angry, demanded that Proctor come back, and he essentially upbraided him and read him the riot act, which shows a little bit about Higgins' personality. At the end of the night, everyone discussed going back to 34 Fairview, and when he gets back to 34 Fairview, he texts not Karen, he texts John O'Keefe at 12:20 a.m. He testified before the federal grand jury that he had no knowledge that they had been invited to 34 Fairview, but that is contradicted by this text message. And the inference is that he was coaxing John to come to that house. And, you know, we're not saying this gives him a motive to kill.
So Brian Higgins potentially was coaxing John to come to the house to fight, perhaps? And Brian Higgins and Brian Albert just came from a funeral and were spending the day all together, so they must be buddies right now, you know, and they're coaxing John O'Keefe to come to the Albert house. But then when they're all interviewed by law enforcement, oh, we didn't even know they were coming. Yeah, okay. This Brian Higgins guy, I think, has been way more involved than we thought. We thought maybe he was just like an ancillary guy in the background, but no. He goes to work at 1:30 in the morning after drinking all night with with Brian Albert. And being at a funeral all day, potentially drinking there too. Who knows?
John, but we don't have to show that. Any motive to feel hostility or animosity towards John O'Keefe goes to his motive. And Your Honor, when Brian Higgins and Brian Albert are in that house, they're the only two people who are unaccounted for when the rest of the group was in the kitchen. And they claimed that they were looking at photographs together. And we have evidence that they were in the basement. We believe that Brian Albert made a mistake before the state grand jury by testifying they went upstairs to look at photos. Brian Higgins says unequivocally that the only place the two went was into the living room to look at photos and military ribbons, whatever they were looking at. Brian Higgins did not know that Brian Albert had said they went upstairs. And he also testified he had never been upstairs at Brian Albert's house in his life. That means that if Brian Albert said they went upstairs, they're coming up from the basement. And before leaving 34 Fairview, Brian Higgins testified he was parked right in front of the mailbox. He would have had to have walked by where John O'Keefe's body was. His headlights, when he got in his vehicle, would have been illuminating where John O'Keefe's body would have been in the yard if it were actually there. So how does he not see it? He then goes back to the Canton police station at 1:30 in the morning after leaving 34 Fairview. He claimed to do some administrative work.
After drinking?
He admitted to the federal grand jury that he was there to move his car because of the upcoming snowstorm. This suggests that he was fabricating a reason for going back to Canton Police to establish an alibi for himself. He was asked several times at the federal grand jury if he had any conversations with anyone before he went to bed. And when was he notified that John O'Keefe was dead? In the morning, he said. He testified under the pains and penalties of perjury that he had absolutely no contact with any person that night for any reason whatsoever. But he apparently was surprised that the federal authorities had subpoenaed his phone records, and he had to admit, and he did admit under oath, he made that 2:22 a.m. phone call around the same about 5 minutes before Jennifer McCabe is Googling how long to die in the cold, about 8 minutes before Brian Loughran, the plow driver, first drives by the house and sees nobody at all. And the next morning, Brian Higgins, the first person he spoke to was Brian Albert.
I'm going to stop you for a minute. I think we need a break, Madam Court Reporter.
This is such a dick move also. He's in the middle of his narrative. He's fired up. He's going. And out of nowhere, the judge is like, we need a break. It's hot in here, she says. Listen.
Porter, Do you need a break? Can you go? How much longer do you think you have with this, Mr. Yannetti? How many more pages, or how long you think?
Yeah, I've got about, in terms of my recitation of the facts, I've done about a page and a half, and I've got 3 left.
Madam Court Reporter, would you like to take a little break? It's hot in here, and you've been going nonstop. Okay, let's take a 10-minute break.
Wow. He was in the middle of getting fired up. What a bitch. I do not like Judge Cannone. Like, sometimes I feel like she's fine, and then other times just like the way she talks to the defense, the way she is with them, you can tell she's biased. And I think judges like this need to retire. They need to recuse themselves when they become this bitter and just, yeah, they need to go away in these cases. All right, so we're going to continue where that left off in just a second. Let me grab the link here. So yeah, she just cuts him off mid-passionate speech to throw him off of his game. Guaranteed, that's why.
I could go through with the court the specific evidence we have with regard to motive, opportunity, and means with regard to the 3 Commonwealth witnesses that I've named.
So go ahead.
Happy to do it.
Same link.
Starting with Brian Higgins. He was present at 34 Fairview Road on January 28th to 29th.
Sorry, I thought. Hold on. Let me make sure. Okay, you go away. Sorry. For some reason, like I'm copying links. It's not okay. Yeah, that is the same. Darn it. That's not the right.
I could go through with the court the specific evidence we have with regard to motive, opportunity.
We heard that already. So this should be when we come back. Hopefully. Yeah, I think it is.
With the morning of January 29th, the first person that Brian Higgins spoke to was Brian Albert. He had missed a call from Chief Kenneth Berkowitz earlier. Immediately after getting off the phone with Brian Albert, Brian Higgins drives back to 34 Fairview, where he has a meeting with just about all the witnesses in this case: Brian Albert, Julie Albert, Jennifer McCabe, Matthew McCabe. And immediately after that friends and family meeting, on his day off, which is a Saturday, he returns to the Canton Police Department, where he speaks with all of the first responding officers who had anything to do with this case. So this is a quote-unquote witness accessing and communicating with all the first responding officers, we would argue monitoring what they're doing in regard to the investigation.
How is that ethical or legal? This case is so full of corruption. It's ridiculous. I mean, I couldn't even write a novel this good. It's so, I mean, not that it's good, that it's real life, but I mean, you know what I mean. It's crazy. It just gets worse and worse every time we tune in.
According to Brian Higgins, he admitted that Chief Berkowitz is one of his best friends, and that's why he had access to all these people. We have a law enforcement witness who will testify to seeing Chief Kenneth Berkowitz and Brian Higgins alone with Karen Reed's vehicle on the afternoon of January 29th of 2022 for, quote, a wildly long time.
So
Brian Higgins and the Chief of Police, Kenneth Berkowitz, or Ken Berkowitz, they're best friends. And apparently they have it on good authority that the two of them were alone with Karen Reed's car for a long time. What was it? A wildly long time? Is that what he said?
With Karen Reed's vehicle on the afternoon of January 29th of 2022 for, quote, a wildly long time.
So is this a name that's been in the materials? Is this a name known to the Commonwealth, or
Yes.
is this somebody new? Okay.
We've now received video surveillance from the Canton Police Department that shows that there is an interior camera in the Sallyport garage where the car was housed. But during the exact time that third-party officer indicates that Berkowitz and Higgins were in the Sallyport together, the video mysteriously cuts out for 42 minutes.
Yet another video surveillance footage thing that goes missing in this case. So we couldn't find the video footage of her from any of the Ring cameras across the street from 34 Fairview Road, or even from 34 Fairview Road itself, because they had a Google Nest, but apparently they didn't hook it up yet. What else? They failed to get the library. The footage from the Canton Library seemed to just cut out the exact 2 minutes where she would have been driving by and her tail light would have been seen. So that went missing. There was plenty of Ring footage from John's house that went missing. Karen did not have access to that. The police, had access to John's phone and could have deleted things from there. So they could have easily done something there. So everything is just adding up and up and up in this corruption, and yet we're still going to trial. I don't get, but let's keep going.
Between 5:08 and 5:50 p.m. And just to be clear here, we never get to see the condition of the taillight when it's brought into the garage. When we do see the car, we see it after Brian Higgins, Chief Berkowitz, Michael Proctor, and Yuri Buchnick have all had access to it. At 5:36 p.m., the car pinged.
All people who are friends with the Alberts. And they should have been recused from this case at this point anyways. So why is it in Canton being looked at by the Canton police chief and Brian Higgins, who is an ATF agent but is in the Canton police station? So yeah, it's all very, very fishy.
That it's arrived in the Sallyport. That's during the missing video. Trooper Proctor, Trooper Buchnick never sees Brian Higgins' phone. They speak with him, and he takes it upon himself to use his own resources, Brian Higgins, within the federal government to ask a friend, Special Agent Matt Kelch, to download only the text messages in his phone between Karen and him and John. And that's it. We have to take his word for it that we got all of them. And we certainly don't have any communications between him and Brian Albert, for instance.
And why do you think Brian Higgins would do such a thing? Instead of handing his phone over and doing an extraction or something along those lines, he hands his phone to a friend who does that kind of a thing, and his friend is asked to only download, extract for the purposes of making copies to provide to the law enforcement conversations between me and Karen and me and Karen and me. But nothing between him and Brian Albert. Nothing like, hey, Brian, psst, help me bury this or help me move this body out of the basement. Nothing like that.
On February 10th, when he shows up to his interview with Troopers Buchnick and Proctor, he brings with him copies of the text that he has deemed relevant in their murder investigation. And he hands them the copies of the extraction that he had his friend do. He then calls Matt Kelch the weekend of this incident to do the limited extraction. He never tells Trooper Buchnick or Trooper Proctor how he extracted the tests, despite the fact that it was done by a friend of his in the federal government. During the federal proffer.
So someone in the federal government did that for him. So more corruption going on in the Fed. area over there. That's great. The feds were supposed to be saving us from this.
Brian Higgins admits that he had been served with a preservation order, and the Commonwealth told him he could destroy his phone despite the order. He then drives to a military base on Cape Cod.
Did you catch that? District Attorney Morrissey gave them permission to destroy their phones, Brian Higgins and Brian Albert. So they drive to a U.S. Air Force base or whatever he just said, which to what I heard or somebody mentioned online, I can't remember what it was, but something I was watching on this, said that it has something to do with the signal, that you can't really get a good signal. They can't track your signal or something. They can't figure out what happened to your phone if you don't have a signal, I guess. So they went and they destroyed their SIM cards in this U.S. Army base or Air Force base, whatever it was. Let me back up a few seconds. I just wanted to explain that because he goes through it quickly.
Extraction. He never tells Trooper Buchnick or Trooper Proctor how he extracted the tests, despite the fact that it was done by a friend of his in the federal government. During the federal proffer, Brian Higgins admits that he had been served with a preservation order, and the Commonwealth told him he could destroy his phone despite the order. He then...
The Commonwealth, District Attorney Morrissey said, you can destroy your phone despite the order to preserve it.
Drives to a military base on Cape Cod, opens his phone, breaks the SIM card, and throws the phone away. And he says that he discussed destroying his phone with Brian Albert. Brian Albert also destroyed his phone. And Brian Albert said that he had received some text that concerns him as an explanation. And after that, Brian Higgins changes his phone number and changes his cell carrier. In short, he was present that night, he had a motive, and there is plenty of consciousness of guilt cover-up evidence with regard to Mr. Higgins. Moving on to Colin Albert. Shortly before January 29th of 2022, Colin Albert lived with his parents, Christopher Albert and Julie Albert, on John O'Keefe's street, just 2 doors down. We have evidence of bad blood between Colin Albert and John O'Keefe. We have evidence.
How old was Colin Albert at that time?
I believe he was 16 at that.
And what does it matter? Yes, he was a minor, but he was the little punk kid that was causing all the problems.
That time.
Okay.
We have evidence that Colin Albert and John O'Keefe used to get in confrontations because Colin Albert used to cut through his yard without permission, and John O'Keefe was not happy about that. We have evidence that Colin Albert used to throw beer cans intentionally into John O'Keefe's bushes, and John O'Keefe was not happy about that. We have evidence that Christopher and Julie Albert knew of this conflict. We have evidence that they referred to John O'Keefe as Nebercracker. That's a character from I think a kid's movie, who was known as the get off my lawn guy. When John O'Keefe and Karen Reed were vacationing in Aruba over New Year's Eve 2022, the Alberts, Christopher and Julie, taunted him. They went to his porch and they had photos taken of themselves drinking on John's property when he wasn't there to do anything about it, evidencing they knew.
So not just Colin, but the adults as well, meaning Chris and Julie Albert. So there's that. Chris and Julie Albert, along with Colin probably, and Caitlin, their minor children, were drinking on John's property, on his patio or porch or whatever he said, in his backyard, and did it on purpose to piss him off. This is the type of people that might cover up a murder, for instance. So yeah, there's that little portion of it. Sorry, let's continue. I don't mean to keep interrupting.
How upset he was at what Colin Albert had been doing. Now, the investigators in this case, Your Honor, including Michael Proctor, kept Colin Albert's name completely out of the police report. When this case began, I had no idea who Colin Albert was. I received a tip right from the jump that Brian Albert and his nephew had beaten up John O'Keefe. I didn't even know Brian Albert had a nephew at that time. But after receiving the tip, I learned of the conflict that Colin Albert had with John O'Keefe, so I sent a letter to Mr. Lally, I believe by certified mail. I knew that the DA's office was planning to present evidence or witnesses to a grand jury, and at that early juncture, before anybody had asked them to indict, I notified the DA of 3 potential suspects, the ones that I'm talking about now: Brian Higgins, Brian Albert, and Colin Albert. After he received that letter at our next court appearance, I'm sure Mr. Lally can confirm this, he acknowledged that both Brian Albert and Brian Higgins would be testifying or had testified before the grand jury, but he questioned why I included Colin Albert in my letter. He told me at the time that he had no evidence that Colin Albert was there that night. However, after receiving my letter, lo and behold, multiple witnesses testified that Colin Albert was at 34 Fairview the night of January 28th to 29th. And now the DA will argue, I'm sure, at trial, that he left before John O'Keefe arrived. We don't find their evidence compelling. We don't accept it. We are not required to accept their theory of the case. We're entitled to present a defense. His presence at 34 Fairview gave him the opportunity, along with the motive, to harm John O'Keefe. With regard to Brian Albert, Your Honor, this is a well-connected, well-known, powerful family in the town of Canton, Massachusetts. Brian Albert was present at that home when Colin Albert was there. Colin Albert is a member of the Albert family. He's nephew of Brian Albert. We have evidence that Brian Albert had expressed hostility toward John O'Keefe as well. And we know that he initiated a phone call with Brian Higgins at 2:22 in the morning. He reached out to Brian Higgins. And then he picked up the phone when Brian Higgins came back, and they spoke for 22 seconds. And they never revealed any of that to investigators. Again, consciousness of guilt, and perhaps most of all, Brian Albert is a first responder. He is duty-bound to help somebody who's in trouble. He was notified that John O'Keefe was in trouble. Brian Albert stayed in his home. He knew what was going on outside. His sister-in-law was out there, civilians, medical personnel eventually arrived.
And John McCabe was in the car calling Nicole Albert, asking her if they were going to come out and help or something along those lines. This is what it sounds like. And it seems like she got hung up on or what, because then it sounds like she calls again, and then she's like, seriously? Or like, really? Like, you're not going to come out and help? Or something like that. I don't know. I can't hear it very clearly, but I'm deaf anyway, so whatever. But you can hear her saying something.
He did nothing. That is also consciousness of guilt. Now, Your Honor, with regard to all of that third-party culprit evidence, to admit it substantively, which I would assert to the court is both overwhelming and powerful. With regard to the Bowden argument here, the police investigated none of that. That didn't come from the Commonwealth. They had a complete lack of curiosity as to what was going on in that house that night.
Yep.
They didn't care. Investigators never went in. The feds investigated, and that's where we got a majority of this evidence. So, you know, to the extent that the Commonwealth now claims that they didn't have notice of this, I beg to defer. They got notice of this when we got notice of this. You know, the Finney case, Your Honor, again, I'm well familiar with it. It stood for the proposition that, you know, if you want to point the finger at a third-party culprit, you've got a constitutional right to do that. And if you want to point out inadequacies in a police investigation, you have a constitutional right to do that.
Absolutely.
And it's for those reasons that I ask you to deny the Commonwealth's motions.
Okay. Thank you.
What is that sigh? Okay. She's so rude. She's so rude.
Any response, Mr. Lally?
Briefly, Your Honor. Just first, again, what the case law requires is evidence and not just mere speculation, or saying that you have evidence is not actually evidence. I do find it somewhat interesting that Mr. Yannetti wrote apparently 4.5 pages of notes but didn't have time to write a motion to admit the evidence that he claims that he has. He references in regard to third-party culprit Dr. Sheridan, who indicated that the injuries are consistent with the fight. He's the same doctor who indicated that the injuries on Mr. O'Keefe's arm were consistent with the dog bite, which was then refuted by the DNA findings from UC Davis, as well as the fact that the injuries are only on one side of the arm. And last time I checked, dogs have teeth on the top and the bottom, and there's no injuries to the bottom of Mr. O'Keefe.
And we learned in Melanie Little's stream when she had the dog expert on that is exactly what would happen, especially if he was wearing a shirt and the dog couldn't get a grip, and that's why there were multiple lacerations down his arm, was because the dog kept going at his arm multiple times, and they get their top teeth in and then they sink in, and as you pull away and with the gravity of their body, it becomes a laceration. And that is exactly what happens. You do not need bottom teeth. In fact, any untrained dog that does bite is probably not going to be doing that great of a job like a cop dog, like a canine, one of their canines, because they're trained to bite on the arm evenly. Whereas in a situation where if John and Colin Albert perhaps got into a fist fight and Brian Albert gets in the way, or involved in it too, and maybe Brian Higgins even, and the dog sees that, the dog's going to attack because his owner's in trouble, and the dog went after John. Absolutely, 100%. I have no doubt about it in my mind. Because where is Chloe? She gone. And the only person that seems to know where Chloe is Jennifer Coffindaffer, who says she went to Vermont or something, was rehomed in Vermont. But for the rest of us, we have no idea if that is true or not.
O'Keefe's arm. Furthermore, the counsel references the federal grand jury materials in which I would say, as has been done numerous times previously, is severely mischaracterized as to what they actually contain. And it's not a crash reconstructionist as it's been alleged here before, it's a biomechanical engineer. And essentially what they did was take painstaking lengths to determine that the defendant's vehicle did not strike Mr. O'Keefe in the back of the head, which is simply something that no one has ever said, intimated at any point ever. There is also a medical examiner in the federal material.
Then how do you explain the lesser or the contusions and he does have a laceration, a rather large laceration on the back of his head, which is at least 2 inches. I don't know if that's a gash or laceration. I don't know what you call it, but he definitely has injuries to his head. And his face is beaten up. His hand looks like he had been in a fight. His knuckles are bruised. His face is bruised. His eyes are swollen. So either she hit him in the head with her tail light, or, which is also just so ridiculous, or he got into a fight in that house. That's what I think.
Who concurs completely with Dr. Scortibello's findings as it pertains to the cause and manner of death. So with regard to each of these. The other thing that I would point out is counsel was counsel record with the Finney case. The Finney case relates to third-party culprit under the Bowden event, so it's not applicable to what counsel was arguing. It is a low standard, but it's also one that the defendant here has not met. It's not one without limits. As it pertains to much of the material that is summarized as far as speculation as to what different things counsel feels mean from various things regarding Mr. Higgins, Colin Albert, and Brian Albert. Just starting with Colin Albert, because that's frankly the easiest. He wasn't at the house, and that's what the federal materials confirm with each of every single of the witnesses.
Yeah, and all the witnesses that are supposed to be suspects have said that, but nobody else has confirmed it. It hasn't been confirmed one way or another, unless maybe someone has his phone. Maybe we know his phone was still at that house now until later that night after Karen left the home. So yeah, maybe there is some proof. I don't know. If not, I don't know if there should be, because definitely it's not right.
That were spoken to by the district attorney's office or the troopers or testified to the state grand jury. They testified to the exact same things in the federal grand jury, that Colin Albert had left the house prior to the defendant and the victim arriving there, and there's absolutely nothing to combat that whatsoever, other than, again, just rank speculation. So opportunity would be...
It's speculation that he wasn't there. You know, I mean, everything that we're hearing is not from Colin's mouth himself, and everything that we're hearing is from everybody else saying that he left the house. So that is hearsay. Hearing it from someone else is hearsay.
A little bit amiss if he's not even there at the same time as Mr. O'Keefe, regardless of the invalidity of any sort of ill feelings or ongoing feud that's purported from whatever unknown evidence counsel claims to have. In regard to Mr. Higgins, that was a fanciful story, but again, there's actually no actual evidence of most of those things, or at least the imputations or the connotations the counsel wants to put behind that. Whatever he feels things were observed. So again, I'm not sure where the evidence from this is coming from. What I'm also a little confused in regard to is that if counsel is merely relying on materials within the federal grand jury and just learned of them at that same time as we learned of them when materials were provided pursuant to TUI, then it's a little peculiar that the exact same arguments were being made throughout the pendency of the case well before counsel was provided with any of those federal materials. What counsel just went through is essentially a list of rank speculation and not actual evidence. As far as the mysterious portion that's missing from the Sally port, there's a number of different, it's a motion activated camera for the most part. The other thing that I would direct the court's attention to, as it was
if it's a motion activated camera, then it should have been activated as soon as Karen Reed's car entered the port, the Sally port, but that's not what happened.
Within the state grand jury proceedings is cruiser camera video from the Canton police cruisers. Specifically, there is cruiser camera video from cruiser 682. Specifically, there is cruiser camera video from cruiser 682 at 8:22 in the morning when a lieutenant and sergeant from the Canton police on their own go over to One Meadows Ave, which is the residence of Mr. O'Keefe, to do a well-being check because they had not received any information as to how the children were or if they were there being attended to. And they pull into the driveway at 8:22 in the morning, directly behind the defendant's vehicle, which is exactly where Ms. McCabe parked it when they stopped there to see if Mr. O'Keefe was there, before then piling into Ms. Roberts' vehicle and proceeding to 34 Fairview. And what you can see within that cruiser camera video at 8:22 in the morning is the damage to the right rear taillight of the defendant's vehicle. well before the defendant had then come back to the house after the hospital and then gotten in 3 separate cars with her family and driven in a blizzard all the way back to her parents' house in Dighton, and then the vehicle had then been towed from Dighton back to the Canton Police Station by the state police with the assistance of the Dighton police.
Do you know what exhibit number that is before the grand jury?
I believe it's 56, but I can certainly locate that information. And again, as far as Brian Albert is concerned, I heard nothing other than he's apparently in a well-connected family in Canton, and Colin is his nephew who wasn't present at the house when Mr. O'Keefe and Miss Reed were present at the house. So, again, I think it's a stronger argument, certainly, if...
That's not true, though, but we also heard about them lying about coming upstairs and looking at the awards or whatever he had, his medals. That's proof that the two of them are telling 2 different stories. So, yeah, I'd want to know more about that.
If we're trying to bootstrap onto a Bowdoin defense, and counsel will probably likely be allowed to at least investigate that as far as impeachment, cross-examination, things of that nature, but there is absolutely nothing beyond just a fertile imagination and rank speculation as it applies to a third-party culprit defense. And for that reason, the Commonwealth's motion to exclude it should be allowed.
The only thing I'd like to correct, Your Honor, is, well, or at least point out, is that, you know, the car pinged at 5:30.
So hold on until you get to the microphone.
Yeah, I'm sorry. The car pinged at 5:36 p.m., indicating that it was in the Sallyport. There is an outdoor camera where you can see the car about to enter the Sallyport at 5:31. Of course, you can't see the tail light in that outdoor, camera. But Mr. Lally just argued before you, well, the reason why there's no, video of the car between 5:08 and 5:50 is that it's motion activated. And I just ask the court to use common sense here that if the car's entering, and by the way, the car's there at 5:50 with a couple of people around it. When the camera comes back on, you see the car. So unless it was teleported in a split second so that the interior camera would not pick up motion, it drove into the Sallyport. I believe that's the definition of motion, and it should have been picked up according to Mr. Lally's own words.
Okay, so when you walk away from the microphone, it's harder for the court reporter to hear you, Mr. Yannetti.
And I apologize, Judge. It's according to Mr. Lally's own words, it should have picked up the movement.
Okay. All right, so I believe that's the last motion. So why don't we recess until 2 o'clock?
Yeah, she doesn't give any real definitive anything. So those were the big highlights of the hearing, and that, we didn't even listen to all of it. So that was just some of it. So I'm actually going to pull up this PDF here, and we're going to go over this. Let me switch screens. That's better. Okay. Hi, there I am. All right. So we're going to go over this the amended complaint by the Lopilato. I saw the word introduction and came out of my mouth. All right. So this is the Lopilato brothers. Remember, we read a little bit about this last time in the document that we read, the unsealed motion to dismiss. So now we're actually going to go further. This was one of the exhibits. So actually it's Exhibit B to be correct or precise. Let me just center it a little better. All right. So the defendants, just FYI, Officer Michael Lank, Officer Glenn Nix, Officer Errol Lane, Canton Police Chief Peter Bright, and the town of Canton. So this must have been before Rafferty, obviously. So I don't know when, and I have no idea when their police chiefs come and go. But anyways, I'm sure it's elected. All right, so introduction. This is an action for money damages on behalf of the plaintiffs Mark Lopilato and Alfredo Lopilato, arising out of a violation of their constitutional rights by Officer Michael Lank, Officer Glenn Nix, Officer Errol Lane, and Chief Peter Bright of the Canton Police Department. Plaintiffs also allege that the town of Canton had a custom and policy of deliberate indifference to the rights of its citizens that resulted in the violation of plaintiffs' constitutional rights. This action is brought pursuant to all those statutes. Okay. Jurisdiction is based upon some bunch of statutes and on the pendant jurisdiction of this court to entertain related claims arising under state. The parties are plaintiff Mark and Alfredo Lopilato, both reside in Norfolk County. Defendants are the town of Canton, which is a municipality duly organized under the laws of the Commonwealth of Massachusetts. Wonderful. All right, so the defendant, Chief of Police Peter Bright, was at all times relevant to this complaint, Chief of the Canton Police Department, acting under color of law, and is sued as an individual and in his supervisory capacity as police chief. At all times, material hereto, it was the responsibility of Defendant Bright to properly train, supervise, and discipline police officers at the Canton Police Department and to implement established law, policies, and regulations at the Canton Police Department. Defendant Michael Lank was at all times relative to this complaint an employee of the town of Canton Police Department and is sued in his individual capacity. Same for Errol Lane and Glenn Nix. All right, so the facts. Let's get to the facts. On October 31st, 2002, at approximately 12:45 a.m., Mark Lopilato was sitting in a friend's car in a parking lot outside the Golden China restaurant in Canton, Massachusetts. We had like a brief little nugget of what this is about in the motion to dismiss, but this gets a little more detailed. So earlier that evening, Mark Lopilato had been in a verbal dispute with several individuals, including an individual by the name of Tim Albert. So Tim Albert's older brother is Chris Albert, and he's also a childhood friend of Defendant Lank, Tim Albert. We also know that Kevin Albert is on the police with Lank and under police, the same police chief. At this time, I'm not sure, but we do know now in current time that he is working there. Kevin Albert, another brother. So there's Kevin, there's Tim, who's this other guy, and then of course Chris and Brian, who we've been talking about for a while. All right, so Tim's older brother Chris is a childhood friend of Detective Lank. Chris and Tim Albert had been drinking that evening at Centerfield's bar in Canton. Defendant Lank was drinking at Centerfield's that evening as well. So we had some drinking going on, guys. While sitting in the car, Mark Lopilato noticed a group of several men leave Centerfield's bar and approach the car. So his car, the car that he's sitting in. At the time, Mark Lopilato exited the car. Why? I don't know. Maybe they called him out. Maybe they wanted to talk to him or, just did something to provoke him to come out, but we don't know. All right. He was then attacked by several of the men in the group, including Chris Albert. After this attack, Mark Lopilato called his brother Alfredo Lopilato and informed him that he had been physically assaulted by a group of men. Plaintiff Alfredo Lopilato left his girlfriend's house, where he had been sleeping, and came to the parking lot out of concern for his brother's well-being. When Alfredo Lopilato arrived, he noticed Chris Albert, Tim Albert's brother. Alfredo knew Chris Albert and thus approached him to inquire about the earlier dispute. At this time, Defendant Lank came from the area in front of Centerfield's bar. He was swaying as he walked. At trial, following this incident, Lank would admit that he drank about 4 beers in the 2 hours he was in Centerfield's. Defendant Lank when you say he drank about, he obviously drank more than 4 beers, because if you're saying that, you're minimizing it, especially on the stand. So come on now. It was at least 6, maybe more, and possibly shots. I don't know. Defendant Lank approached the defendants as they approached Chris Albert. He began yelling that he was a police officer. So Michael Lank is just yelling, I'm a cop, I'm a cop, I'm a law enforcement, you should do what I say, probably. That's what he was saying. So his breath smelled strongly of alcohol. At the trial following the incident, Lank would testify that he activated himself as a police officer at this time. What does that even mean? You activated yourself as a police officer? Come on, buddy. You've been drinking all night. You need to take it down a notch. 2 other Canton police officers, Defendant Lane and Defendant Nix, arrived at the scene. Defendant Lank instructed them to handcuff plaintiff Alfredo Lopilato. Defendant Nix handcuffed Alfredo and placed him in the back of the police cruiser. While the other officers were placing Alfredo in the police cruiser, Defendant Lank approached Mark Lopilato, pushed him backwards, then punched him with a closed fist on the side of the face. So the other cops aren't even like watching, because they're getting Alfredo into the car, and then here comes Michael Lank coming at Mark Lopilato, pushing him, punching him, and no one stopped it. Plaintiff Mark Lopilato fell to the ground. Defendant Lank landed on top of him. Defendant Lank continued to hit Mark Lopilato. Defendant Lank then bit plaintiff Mark Lopilato on the arm, breaking the skin. Okay, so is he a dog now? I mean, did you leave bottom teeth? I mean, it's not funny. I feel bad for Mark and his, wherever he was bit. No one wants to be bit by a human being. I mean, no one wants to be bit, period, but by like you expect an animal might bite you. You don't expect a human to bite you. Not usually. Anyways. So he did not ask Lopilato for any identifying information. He simply told him to leave. So Defendant Lane, did I read that right? Defendant Lane pulled Defendant Lank off. Oh, sorry. I skipped that part. Sorry. Defendant Lane pulled Defendant Lank off of Mark Lopilato. He did not ask Lopilato for any identifying information. He simply told him to leave. So Lane is like, let's just get these guys out of here and hope that nothing ever comes of this. While Alfredo Lopilato was sitting handcuffed in the back of the cruiser, Defendant Lank approached him and spit directly in his face. Defendant Lank then asked Alfredo who the other kid was, and then said, whoever he is, I'm going to make his life miserable. Defendant Lank's speech was slurred and his breath smelled of alcohol. That's twice now we've heard that. He's smelling like alcohol. After Defendant Lank spit in Alfredo Lopilato's face, Defendant Lane released him from the handcuffs. Oh, so now you do. Okay, thanks. Lopilato asked, did you see him spit in my face? Defendant Lane responded, just get in your car and leave. Could you imagine this happening to you and how furious and humiliated you would feel for and outraged that they use their power to take advantage of you? I would be just, but yeah, I wouldn't even know what to say. I probably would have just got my car and left. Defendant Lank drove away after the incident despite his obvious intoxication. The next morning, Saturday, August 31st, 2002, I thought we were on the 31st, so maybe that was the 30th that we were just reading. I don't know. Alfredo Lopilato went to the Canton Police, so the very next day, he went to the Canton Police Station to make a complaint with Internal Affairs on behalf of his brother and himself. He was sent away and told that he would have to come back on the following Tuesday, the 3rd, if he wanted to make a complaint. So he went in there the very next day ready to complain about law enforcement, which isn't an easy thing to do because who are you complaining to about law enforcement? Law enforcement. So it's not easy. They sent him away and then tell him you can't come back until next Tuesday. So he had to wait over a week. Or no, the following Tuesday. No, he only had to wait a couple days, sorry. If he wanted to make a complaint. Alfredo asked Mark if he would go to the police station on that date as Alfredo would be working. Police reports regarding the incident were not drafted or filed until September 2nd. This was only after Alfredo Lopilato went to the station on the 31st to complain about the conduct of the defendant officers. On the following Tuesday, September 3rd, 2002, Mark Lopilato went to the Canton police station to make a complaint on behalf of himself and his brother. He spoke with a sergeant and described the officer's conduct during the incident. The sergeant told him he would get back to him regarding the incident or regarding the complaint. That evening, someone from the department called Alfredo and stated that she would look into the complaint. To this day, neither Mark nor Alfredo Lopilato has heard anything further from anyone in the Canton Police Department regarding the outcome of any investigation into their complaint. Soon thereafter, both Mark and Alfredo Lopilato received a summons in the mail to appear in court on September 25th. They each had been charged with assault and battery on a police officer. These cops were using their power and abuse, their power to abuse them, their power to get them to comply because I'm a cop and you have to listen to me type of thing. And yet now we are, sorry, I'm cold. I'm trying to get under my blanket. It's moving the cord. Whew, that's better. Okay. So they each get assaulted. I mean, I'm sorry. They both were assaulted, and yet now they're being charged with assault and battery of the police officers, which is just crazy. It's the exact opposite, and this is wrong in so many levels. So on the evening of February 6th, 2003, Mark and Alfredo Lopilato went inside a mobile gas station in Canton. Their other brother, Chris Lopilato, and several other individuals were waiting for them in a vehicle outside. Defendant Lank entered the store and asked Mark Lopilato how he was doing. He replied, "Not so good. You attacked me, and now I am the one who has to go to court." Mark and Alfredo Lopilato went outside to get in the vehicle. Suddenly, several cruisers appeared. Defendant Lank then ordered Mark Lopilato to get into his cruiser. While in the cruiser, Defendant Lank asked, "Can we talk about this now?" When Mark Lopilato did not reply, Defendant Lank placed him under arrest and instructed another officer to take him to the police station. Can you believe this? This is real life policing in 2003. And it's not that long ago. Lopilato was booked and held at the police station. He was released at 3 a.m. and arraigned the next morning on the following charges: threatening, disorderly conduct, and intimidation. On October 23rd, 2003, after a 3-day jury trial, Mark and Alfredo Lopilato were found not guilty on all charges arising out of the August 31st incident. All of the charges arising out of the February 6, 2003 incident were dismissed at the arraignment that same morning. The Assistant District Attorney, that's Michael Morrissey, who handled the matters, apologized to Mark Lopilato and stated that after the October trial, he realized that Defendant Lank was a liar. And that's a quote. Defendant Lank was a liar. And that's coming from District Attorney Michael Morrissey. Oh, actually, no, I'm sorry, the Assistant District Attorney. At the time, in 2003, I have no idea who it was. So I take that back. I don't think that was Morrissey necessarily. Well, no, Morrissey has been in charge for like ever. But assistant district attorney, I don't know who that was. All right, so as a result of the defendant's conduct, Mark Lopilato suffered physical injuries, humiliation, embarrassment, and emotional distress. Alfred Lopilato suffered humiliation, okay, same thing, plus economic losses. Count 1, violation of whatever statute by links. These are all going to be very similar. So the plaintiffs restate and reallege paragraphs 1 through 38 and incorporate said paragraphs herein as paragraphs 39. By the actions described in paragraphs 1 through 38, defendants Lank, Nix, and Lane, acting under color of law, violated plaintiffs' rights to free speech and to petition the government for a redress of grievances in violation of the U.S. Constitution and their rights under the First and 14th Amendments, also our Constitution. Stupid bus. There's a bus like by my house 10 times a day. It's so loud. To be free from excessive force and unlawful seizures in violation of 42 U.S. whatever Constitution. That's the word I was looking for. U.S. Constitution and the 14th and 4th Amendments to the United States. Count 2, the plaintiffs restate and reallege everything above by actions described in those paragraphs above, has through his actions and omissions shown a deliberate indifference to the plaintiff's constitutional rights and deprived the plaintiff of their constitutional right to free speech, to petition, and to be free from excessive force and unlawful seizures. Failing to take advantage of easily available measures to ensure his officers did not engage in constitutional violations. Failing to adequately train his officers. So these are the things that they're finding the fault with Canton PD for. Failing to adequately train officers, failing to adequately train on the rights of free speech, the right to petition, the use of force, and on guidelines for proper seizures. Failing to adequately train, supervise, discipline officers whom he knew were prone to violate the rules, to violate the right to free speech, So, failing to adequately train, I don't know, excessive force and illegal seizure. So, making sure that your officers understand and are aware of the differences of both excessive force and illegal seizures. All right, so tolerating a custom and practice in which officers violate the right to free speech, violate the right to petition, use excessive force, and make improper seizures, and failing to adequately investigate incidents where he knew officers violated the right to free speech, violated the right to petition, used excessive force, and made improper seizures. Like a hair on my face that won't go away. The plaintiffs restate and reallege all of that again. Okay, I don't want to read all this. This is boring. There was more. Okay, so wherefore we request that this honorable court award compensatory damages against the defendants jointly and severely. So all of them should get some kind of monetary admonishment or sanction or whatever you want to call it, and then it should be severe too. Award punitive damages against defendant. Award the costs of this action, including reasonable attorney's fees, and award such other and further relief as this court deems necessary. So you can give me $3 million for the first one, compensatory, and then punitive is like, so compensatory is like what I lost. You're going to give that back to me. So I'm going to say like, my job, I lost my form of income, I lost my way of living, I lost all these other things about myself. So that all adds up, and let's just say that's $4 million, whatever. And now punitive damage would be, I want to punish, punitive, impugn them. Like, I'm going to make sure that you feel it. So I'm going to put, yeah, so I don't know. I just lost my train of thought. I went blank for a second. This happens to me every stream. So if you're a watcher of my show, this is me with all my flaws and everything. So I don't like to try to fluff up my videos and make it look like I'm perfect, because I am far from perfect. So I leave in all my mistakes as well. So anyways, this is what they're asking. Punitive damages, obviously, to punish. Compensatory is to compensate me for what I've lost. Also, the cost of this action, so whatever legal fees, and what if the court sees that you should give me more, go right ahead. And there was a little bit to Exhibit C here. So this is the settlement order of dismissal. So the court, having been advised on November 21st, 2007, that the above entitled action has been settled, it is ordered that this action is hereby dismissed without cost, and without prejudice to the right of any party. So basically, this is dismissed. This is no longer on my docket. This is not my problem anymore as a judge. So here's Exhibit D, which is the joint pretrial memorandum. The parties respectfully submit the following pretrial memorandum: statement of the evidence parties will offer at trial. So the plaintiffs, in the early morning hours of August 31st, Mark Lopilato was beaten and bitten by defendant Michael Lank. Just before the assault, defendant Lank had been drinking in a local bar. After activating himself as a police officer, he intervened in a conversation between plaintiffs and several of his childhood friends. He stated he was a police officer and physically inserted himself between the parties. When Mark Lopilato told him to get out of the way, defendant Lank sucker punched defendant Mark Lopilato, wrestled him to the ground, and bit him in the arm, leaving severe bruising. Defendant officers Lane and Nix were present as well. Defendant Nix handcuffed Alfredo Lopilato at defendant Lank's request. So he just handcuffed him because he told him to do so, even though they had been drinking, and placed him in the back of the police cruiser. Defendants Nix and Lane pulled defendant Lank away from Mark Lopilato. When Mark Lopilato asked defendant officer Lane if he had seen what had happened, defendant Lane stated, "Get the F out of here before I arrest you." Following the officer's orders, Mark Lopilato left. He had sustained a black eye and bruising. His arm was wounded with a deep bite mark. Defendant Lank then approached the police cruiser where Alfredo Lopilato was being held and asked, "Who's your buddy?" Then Lank stated, "I'm going to make your life miserable," and spit in Alfredo Lopilato's face. After approximately 45 minutes, Alfredo Lopilato was released. The next day, Alfredo Lopilato went to the police station to make a complaint against the involved officers. He asked to speak with the lieutenant or captain and was told to come back on Monday. He left his phone number. On the following Monday, Mark Lopilato went to the station to make a complaint. He spoke with a sergeant, showed him the dog bite, and described the officer's conduct during the incident. The sergeant told him he would get back to him regarding the complaint. On the following Tuesday, Alfredo called the department and made another verbal complaint and stated he wanted to come in and speak with someone. You got to be your own advocate, and you got to do it repeatedly over and over again. If people aren't listening to you, you got to make them listen. So I admire Alfredo for staying consistent. So the officer with whom he spoke stated that she would look into it and get back to him. That evening, someone from the department called Alfredo and stated that she would look into the complaint. To this day, neither Mark nor Alfredo Lopilato has heard anything further from anyone in the Canton Police Department regarding an investigation into their complaints. Instead, several days after making the complaint, both Mark and Alfredo received a summons to appear in Stoughton District Court on charges of assault and battery on a police officer. It is mind-boggling that they have the balls to do this. On the evening of February 6, 2003, while the charges arising out of the August 31st, 2002 incident were pending, Mark and Alfredo Lopilato went inside a mobile gas station in Canton. Their other brother, Chris, and several other individuals were waiting for them in the vehicle outside. Defendant Lank entered the store and asked Mark Lopilato how he was doing. He replied, "Not so good. You attacked me, and now I'm the one who has to go to court." Mark and Alfredo Lopilato went outside to get in the vehicle. Defendant Lank then ordered Mark Lopilato to get into his cruiser. While in the cruiser, Defendant Lank asked, "Can we talk about this now?" When Mark Lopilato did not reply, Defendant Lank placed him under arrest and instructed another officer to take him to the police station. Lopilato was booked and held at the police station. He was released at 3 a.m. and arraigned the next morning on charges of threatening disorderly conduct and intimidation. Man, they love to weaponize that intimidation law. On October 23, 2003, after a 3-day jury trial, Mark and Alfredo were found not guilty of all charges arising out of the August 31st incident. All of the charges arising out of the February 6th incident were dismissed. Since the incident, the Lopilatos have been pulled over repeatedly for motor vehicle citations in Canton. The defendants expect the evidence to show that on August 31st, 2002, the defendant Lank worked a 12 to 8 shift on August 30th and worked a detail from 8 to 4 p.m. He went home, slept for a period of time, and then went to a friend's house to attend a wake. He left the friend's house and went to Centerfields. He arrived there at approximately 10:30 to 11 p.m. He stayed there until closing time, consuming 4 to 5 beers. While leaving the restaurant, he was asked by the owner, Jim Maranthus, to drive another patron home. He got in his truck and was about to leave when Chris Albert approached him. Mr. Albert was with his wife, Julie, and indicated that he had just gotten into a fight with Mark Lopilato, and Mark had made threats against him. Oh my God, you're such a baby, Chris. What a whiny little baby. You're like, oh, he was mean to me. I want to go tell it him. Officer Lank observed Mr. Albert's hand to be swollen. While speaking with them, Officer Lank noticed a group of men coming down the street. Mr. Albert backed away and said it was Mark and his brother coming down the street. Officer Lank exited his truck and walked towards the Lopilatos. He identified himself as a police officer and told them that there would be no more fighting. Sorry, my dog barking again. All right. He identified himself as a police officer and told them that there would be no more fighting. The plaintiff said they did not care if he was a police officer. Officer Lank held up his hands and got in between both groups. Mark and Alfredo began to slap at his hands. Mark then grabbed him and tried to push him. Officer Lank held on to Mark until they separated. Mark then punched Officer Lank, striking him in the ear. Officer Lank returned a blow and they began to wrestle and trade blows. He felt someone hitting him in the back of the head and turned to see Alfredo Lopilato behind him. So, if you guys are punching and spitting on and doing all this stuff to Mark and Alfredo, are they not allowed to fight back if it goes blow to blow? Like if it turns to that? Like they're not allowed to fight or protect themselves because that's right, you're an officer of the law, so they can't hit you or you'll take them to court. At some point, the defendants Nix and Lane arrived and the groups were separated. A decision was made to summons in Mark Lopilato as well as his brother Alfredo. Officer Lank contacted his supervisor that night, who informed him he could write his report when he returned to duty, which was 2 days later. Officer Lank later completed his report and had the plaintiffs summoned into court for assault and battery charges. A clerk's hearing was held and the complaint was issued. During the pendency on the criminal charges, Officer Lank was on duty and went to the local mobile mart for a drink. While in the store, the plaintiffs came in and began to make statements to him, saying like, "You're a pussy, you wanted no part of me that night, we will get you." Okay. If you say so, Officer Lank. I doubt that they would say that to an officer, especially after what you already did to them. I really doubt that. But anyways. Officer Lank initially brushed their comments off and left the store. While in the parking lot, Mark Lopilato threatened him further. Officer Lank called for backup and placed Mark under arrest and charged him with disorderly conduct and intimidation of a witness. Mark was transported to a station by another officer. Mr. Maranthus was the owner of Centerfield. He testified during the criminal trial that earlier in the evening, 9 p.m., there was an altercation between the plaintiff, Mark Lopilato, and Tim Albert. He called the police because Mark refused to leave the premises. The police arrived and the dispute was cleared up. He then testified that around 12:30 a.m. he was outside his establishment talking with Officer Lank. He requested that Officer Lank drive another patron home because the patron had too much to drink. He testified that Lank did not appear intoxicated. At that point, he observed Tim Albert walk towards them and indicate that he was just in a fight with Mark Lopilato and that Mark had threatened to end his life. Maranthus testified that Lank told Albert to go to the police station to file a complaint. He then observed, he told Tim Albert to go file a complaint. He then observed a group of individuals walking towards them. Officer Lank exited his truck and walked towards the oncoming group. He identified himself as a police officer and said there would be no more fighting. Maranthus indicated that the plaintiff, Mark, said that they did not care if he was a cop and a fight ensued. He called 911 from his cell phone. He did observe Mark Lopilato fighting with Lank. Officers arrived and the fight was broken up. There were no stipulations of facts, and at this time, all facts are being contested. Questions raised by pending motions. The defendants intend to file a motion to bifurcate, which means, I think it means to like break up and do in two. Like if you have a DP case, a death penalty case, and you want your what's it called? So like your regular jury trial happens, but then you can have a separate trial just for like your sentencing, basically, for, you know, whether you're going to get the death penalty or not. So defendants intend to file a motion to bifurcate. Plaintiffs intend to oppose this motion. Defendants also intend to file a motion in limine to exclude evidence of unrelated, unsubstantiated misconduct on the parts of the officers. Plaintiffs intend to oppose this motion. Well, yeah. Plaintiffs intend to file a motion to amend the complaint, adding a additional theory of recovery under 1983, namely that the defendants violated the plaintiff's First Amendment rights. Issues of law, including evidentiary questions, none. No requested amendments, no additional matters to aid in the disposition of this action. Plaintiff's expected trial witnesses. So this is a list of everybody's, or this is the plaintiff's witnesses, sorry. The parties to the action, all these people. So Tim Albert, Brendan Albert, Chris Albert. That's interesting, huh? Oh, Julie Daniels makes an appearance. If you follow Turtleboy, you know who she is. She might have been one of the people that was there, but we just never mentioned. We know she's just one of them that is she related to them? I can't remember. I don't know. But she comes up often on the Turtleboy show. So he talks about her. Well, she was obsessed with him because she kept calling him like live on the show. It was funny. All right, so I don't know any of these other names. Officer Seraph, he was in, he's the first one on scene to find Karen, Carrie, and Jen all standing around John. He was the first one on the scene. Nothing else really that is important here. I just wanted to see who the dental records for Officer Michael Lank. I wonder if they did some kind of bite mark comparison, which is total bogus anyways. But yeah, that was it. I thought there was a defendant's witness list, but it wasn't there. Oh wait, did I miss it? Oh no, this is the other redacted stuff, which is like pictures from Proctor's sister's wedding, and Proctor's there and whatnot with Colin Albert and all of them. But that's the end of what I had for you today, which was the interesting story of the Lopilato brothers and the way that they were treated by Officer Sergeant Lank, who is interestingly still practicing law as an officer. After all that happened, which I would think he shouldn't, maybe, or he should have gotten punished severely for what had happened. But in my opinion, I don't think he should be a cop anymore for after that. You start beating people up and using your power in that way, I don't think you should. I think the power's gone to your head and there's no coming back. You shouldn't be a cop anymore. That's my opinion, and I'm sticking to it. All right, well, thank you so much for watching with me. Please hit the like button on your way out. Don't forget to subscribe and make sure the notification bell is on, because I will be doing updates daily for the Karen Read case. So don't forget to subscribe and make sure notifications are going. So thank you so much for watching. Take care. I will see you in the next one. Bye now.
If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.